Good morning. Good morning, Judy, Carla. Nobody else made it over? Well, and we have 5 people. I have lurkers, I guess. Well, hello, everybody. My lurkers, my replay crew, everybody, I love you so much. Thanks for being here. We are on Karen Reed Verdict Watch. We are still doing the coroner affair murder trial. But we are also on Verdict Watch for Karen Reed. So right now, all we have is a fan. I don't know. Yay, Terry made it. Or anything. Day 36. 4th day of Verdict Watch. Well, it's only 9:02 here by my clock.
Hear ye, hear ye, hear ye. All persons having anything to do before the Honorable Beverly Canoni, the Justice of the Superior Court, now holding in Dedham within and for the County of Norfolk. Draw near, give your presence, and you shall be heard. God save the Commonwealth of Massachusetts. This court is in session.
Good morning, counsel. Good morning, Ms. Reed. Good morning, jurors. So I have to ask you those same 3 questions before we send you back out to deliberate. Was everyone able to follow the instructions and refrain from discussing this case with anyone since we left yesterday?
Yes.
Everyone said yes and nodded affirmatively. Were you also able to follow the instructions and refrain from doing any independent research or investigation into this case?
Yes.
Everyone said yes or nodded affirmatively. Did anyone happen to see, hear, or read anything about this case since we left yesterday? Everyone said no or shook their heads. Well, with that, Mr. Foreman, thank you all. We're going to send you back out to deliberate.
All right, please. Here to follow me. Jury is exited the courtroom. Please be seated.
All right, counsel, I think it worked out well having everybody planning on being here at 4 o'clock and being no more than 10 minutes away. So we'll see you here a little bit before 4 this afternoon.
Thank you.
All right. Let's get the recess. Please exit the courtroom.
Okay, before we go over to the other trial, I said this in my other stream, but I'm going to say it again because Carla wasn't over there. So I watched Turtle Boy last night, and he said that when they came back to the courtroom for questions yesterday, that they were all huddled around the defense table looking at the questions, trying to decide what to tell the judge or whatever, I guess. and then they told Karen's parents what the questions were, and they started crying. And then, so Turtle Boy, because he was there in the courtroom, he didn't quite know how to interpret that at first. And then Karen looked at him and had the biggest smile on her face. He said the biggest smile I'd ever seen. So that's good. And everybody seems to think that it's the OUI charge. That they want to charge her with the OUI and nothing else. And that's what the question that Turtle Boy and everybody he's talked to, I didn't get a chance to watch Lawyer, and kind of what Vinnie Politan said yesterday when we were watching it is like the OUI seems to be what they're focused on. And the question, the example, they said example, charge 2, question 5, if we want to just charge her with her lesser, does it charge her with the overall? Meaning, if they just charge her with 5, which is OUI, does that automatically charge her with the manslaughter? Because the forms are confusing. The way the defense had it, it was stop. If you charge her with this, stop. If you don't,
little bit. It was
going.
about question number after the third question that was read by that judge.
So, I was gonna watch. I hope StreamYard can handle putting stuff. Yeah, I was gonna watch them because I figured that would be the best way to gauge what happened. But when I saw Turtle Boy live, I thought, well, let me see. Because usually I go to watch his lives and then I'm like, he's cussing up a storm or he's just telling stories, BS stuff. But it was good last night. So I never got around to watching Peter and Papa George. So, but, the thing about Karen smiling and being happy about it, that made me feel a lot better. Because if Karen's happy, Turtle Boy was talking to another journalist, that had given, she actually gave Turtle Boy her press pass or whatever so he could get in. And she was Jessica Machado, I think was her name. I don't know who she's a journalist for or if she's an independent journalist, but she made it to where, why is this still on? She made it to where Turtle Boy could get in yesterday. And so he had her on his show last night. Jess Machado, yeah. And she didn't seem as optimistic. Like, well, she didn't understand the jurors' questions. She didn't seem to understand what they were asking. And she kept saying she didn't see how the 3 questions were related. Oh, Fall River News, but now she's independent. Okay. I knew you would know. But she didn't see how the 3 questions were related. The one was about what time was the OUI, and then it was how much weight, or is the clips of Karen Reed, if those were evidence, and how much to put weight on them. And the last one was about the OUI charge. And she didn't know they were connected. And Turtle Boy explained to her the clips, probably the clips they're talking about, are the ones where she admitted to drinking and driving. So, and then she said, well, how does that help anything for charge with OUI. How did that give justice to John Keefe or help his family or anything? And who's gonna be happy with that? And Turtle Boy's like, Karen Reed's gonna be happy with that. Karen's gonna be happy. Yeah, I can understand them just finding, because that's all she did. That's the only thing she did that was wrong. She didn't. She drove drunk, and at this point, this might just be me. And yes, I think if you drive drunk, yes, you should be punished. But at this point, I think the woman's been punished enough. I don't think she's ever gonna drive drunk again in her life. So, do you think at this point that any juror would answer no to Bev's questions? No. No. I absolutely think if they were to be looking up stuff on their own, yeah, they're gonna tell her that they are. No way. Absolutely not. Um, would love to have a verdict today. Absolutely love to have a verdict today. Especially because I'm going to the dispensary this afternoon and there's a guy that works there that we have in-depth conversations about. He knew nothing. We were talking about dials. Still, I got on the subject about dials. I have no idea, but we did one day, and so I started telling him about this trial. And so now, every time we talk, there's more. I update him on this trial. So if we could get a verdict today, I would be so happy, because then I can go in and be like, they found her not guilty. And then I realized the last time I talked to him, I realized I didn't tell him about the red Solo cups. And I was like, did I tell you about the red Solo cups? He goes, no. What about red Solo cups? I'm like, they collected the blood evidence and red Solo cups. And he goes, what? I said, yeah. They collected the evidence in red Solo cups. And he goes, the cops? I said, yeah. They said they didn't know how to collect blood evidence in snow in Massachusetts. He's like, what? Like, yeah. The defense asked for the OUI lesser included, and it may just have paid off. Yep. Yep. Well, I think that's why I I don't think the CW proved OUI. The blood test was too late for me. Yes, Judy. And I think that's why the slip is worded the way it is with the two, because it says it says driving under the influence and or is it just or drinking with a BAC of 0.08%. I think that's why it's worded like that. So it doesn't have to be a BAC percentage, just under the influence. Hey, Robbie. So I think that's why it's worded that way on the slip, because of the late BAC. They did not prove what the BAC was. And the way she describes the way she drank is weird. Like, she got a drink and it tasted really weak, and so then she put a shot in it, and then she sipped on it, but then, like, she'd put another shot in it or something. I can't even, the way she described it, I can't even tell how much she had to drink. But the way they did the test and the back extrapolation, there's no way to prove whether she was drunk or not. Yeah, she had a lot to drink. So did everybody else. But nobody says she acted impaired. Nobody. So, I don't know. Okay, let's go back to this other trial that we already have a verdict for. If I can find it again. On YouTube? What are you doing? My computer is so slow. Why are you so slow? Oh, they already have a playlist on Court TV because it's over now. They already sentenced her. Oops. Sorry. Hey, Jill. You guys didn't hear that. I didn't say that. Where is day 4? There it is. I have got to learn that what I think doesn't have to come out of my mouth. I know, I'm sorry.
Bring the jury in.
Get you to state your name and then spell your last name for the court.
I'm Benjamin A. Wells, W-E-L-L-S.
Mayor, you are?
Yes.
Thank you. Lieutenant Wells, where do you work?
I work for the Horry County Sheriff's Office,
And how long have you worked there?
24 years.
What is your current position there?
I'm a lieutenant over electronic crimes.
What types of things does the electronic crimes unit do?
We take cell phones, computers, and analyze it to identify anything of evidentiary value.
How long have you been concentrating on electronic crimes?
Since 2010.
Did you receive any special training in order to work in electronic crimes or deal with electronic devices?
I have.
Can you describe what you've done?
I have been to the Federal Law Enforcement Training Center in Glencoe, Georgia, and seized computer evidence recovery and digital evidence acquisition specialist. I'm a member of the Secret Service Cyber Crimes Task Force. I've been to the Secret Service has trained me at National Computer Forensics Institute in Hoover, Alabama. I have various vendor trainings and certifications.
What's your educational background?
I have an associate's degree in information technology. I have a bachelor's degree in computer forensics and digital investigations, and I'm currently pursuing my master's in digital forensics.
How much longer do you have in your master's?
Hopefully December.
Okay. Do you teach any seminars or courses in digital forensics?
I do. I'm a subcontractor and I teach Cellbrite.
Teach what?
Cellbrite certifications.
Thank you. Are you also a member of this Attorney General's ICAC task force?
I am. I do computer forensics for the Attorney General's office for
So, because you teach it, I am assuming you are familiar with the Cellbrite software.
The software works in a way to forensically pull the evidence or information off of a device and put it in a readable format so it's easier to go through and find stuff.
Is that readable format a report, like a Cellbrite report?
It is. It's a UFED reader report we generate with the software.
What do you mean UFED reader report? And then is that UFED?
It's Universal Forensic Evidence Device. It's used for there's two separate programs. There's one for the extraction, and then there's one once the extraction is off the device, it is parsed and analyzed and put into that readable format.
Is that readable format searchable by any user?
Yes, the Cellbrite reader, Cellbrite's proprietary, which you have to pay for a license, but the reader is a solution for the software to be able to give for free, so you can still go through it and look at the contents of the device.
Can you search by, for instance, a keyword or look for a photo?
Yeah, there's lots of different search criteria. You can search through words, hash values, and different other categories, and many different.
Has Cellbrite been accepted as a forensic tool in courts across the country?
It has.
Are you, and again, you teach it, so I'm assuming that you've been trained in Cellbrite.
I have.
Okay. How long specifically have you been using it?
I've been using Cellbrite close to 13 years, 14 years.
And you mentioned that you have certain vendor certifications. Do you have any certifications from Cellbrite?
I do.
Can you tell us what they are?
I have a CCO, which is a certified Cellbrite operator, certified Cellbrite physical analyst.
I forgot to read Judy's info for this case. Judge Culbertson attended the Citadel from 1977 through 1981, graduating with a BA in history. Judge Culbertson then attended the University of South Carolina School of Law, graduating in 1984. He was in private practice while serving as judge first as an assistant municipal court judge until 2007 when he was elected circuit court judge. Is there a judge school? Or is that, do you learn the judge stuff in law school? Or is there a special judge school you have to go to before you can be appointed or run for judge, or however that works? And also, Erica Walsh, who was arrested for her sweatshirt and forced to strip to a sports bra, has a hearing today on her case. And it hopefully it will be dismissed. We hope so. Uh-oh. Oh, no. I dropped a great big old giant piece of cheese. I thought Spike got a special treat. Yes, and no court tomorrow. We may be here. I don't know yet. So I don't know. We'll find out. Let me speed this up. Let's see if we can get through the rest of this trial. I might take tomorrow off. I don't know yet. If it's too fast, let me know.
Advanced cell course for parsing and analyzation, and I also have what's called the CCME, the Certified Cell Rate Mobile Examiner. Yes, certification that you can get within the company.
What is required to obtain those certifications?
You have to take the classes and pass a graded test.
Are you familiar with a tool called Gregory?
Right.
And what is that?
Gregory is another extraction tool. It is used to get the data from the device, the same as cell rate.
Have you been trained on using that tool?
I have.
And have you received any certifications in that?
Yes, I have the Gregory certified operator.
Approximately how many electronic devices have you examined using either Cellbrite and or Gregory?
I would venture into the thousands.
Okay. When you talk about data on a phone, what do you mean?
Well, of course, when somebody uses a device, and it has to have those records in ones and zeros. So it's anything that the user will interact with the device, system interacts with the device, and to be able to see exactly what's on it. It kind of paints the picture of the data on the device.
And when you say extraction, what do you mean?
Well, because you don't want to search a device on the device because then you're altering evidence. What we do is we forensically acquire that copy in order so we can manipulate and work with that, and then we can validate it and verify it against them.
Well, when you say manipulated, are you changing? Are you changing any data in the extraction?
No, that was actually a very poor choice of words, but it's not manipulated, but it's to be able to go through it and, be able to see the different categories and see what is exactly there.
Have you ever been qualified as an expert in the field of digital forensics in South Carolina?
I have.
Approximately how many times?
Twice.
And were you asked to extract data from phones in this case?
I was.
Are you always able to extract data from a phone?
I am not.
What affects whether you can extract data from a phone?
Well, there's a lot of different things. It just depends. It could be encryption. It could be passcodes, hardware, newer versions. We're always trying to fight. We all know that our cell phones, they come up with security updates all the time. There's just a plethora of things that can keep us from getting in the device.
Are there different types of extractions?
There are.
What are they?
Well, there are three basic ones, which is your physical extraction, which is a complete extraction, physical extraction of the ones and zeros, which has what's called unallocated space. That unallocated space is deleted material. Then there's file system extraction, and that's basically all the files that are in the file system, in the user file system. And then there's what it's called an advanced logical or logical, and it is basically what you see on the device.
Now, when you talk about unallocated space for deleted items, does that unallocated, and I may not be using the right terminology, but does that unallocated space ever get written over so it would be potentially you would be losing deleted device?
In a physical, yes, in physical extraction, yes.
Your Honor, at this time I would offer Lieutenant Wells as an expert in digital forensics.
All right, any challenges or questions?
Yes, sir, a few questions. So, it's my understanding, I can kind of get over this. Which kind of extraction did y'all do? Physical or logical? What was
Whatever we can get.
Which extraction did you do? Which type? The category?
It depends on which device we're talking about.
Okay. Which devices did you extract in this case?
Objection, Your Honor. I haven't even gotten the extractions in this case. This is just about whether or not Lieutenant Wells is an expert.
All right. I'll send you this.
Okay. All right, let's ask you this. In terms of, what I think I heard you say was you did some physical in this case and some logical. Is that right?
Again, Your Honor.
I'm gonna allow that. Okay.
It depends on the device. If there's some devices with file-based encryption that you can't do with physical.
Okay. All right. Let's talk about your training. So you're still in the process of completing your training. Is that right? In digital forensics, you're looking to get your master's.
Completing my master's, yes.
Okay. In 2000, was it 4 years removed? So in 2020, where were you in your educational journey?
Completing my bachelor's.
You started it in 20, take a while.
Well, maybe, well, maybe my associates, and it could be, I'm not exactly sure when.
Okay.
But before that, I'd received trainings throughout from the Secret Service and throughout the Department of Homeland Security in order to further solidify everything. I wanted to put a official degree behind it.
Sorry, I didn't understand that response.
I had a lot of training beforehand.
Okay. All right, that's fair. And remind me what that training beforehand was specifically in.
Specifically in, I've done trainings in advanced cell phone forensic acquisitions, advanced cell phone analyzation, network intrusion, cyber intrusion.
Okay, and those things sound more to me like, this is what I'm trying to understand. That training sounds like it is more related to finding out if somebody has committed like a cyber crime. Is that fair to say?
There are trainings within that do that, yes, but this is what we call dead box forensics or mobile forensics.
Okay. What specific training do you have related to extracting data from the phone?
From extracting, I have the CCO, CCPAs, which were week-long courses with the extraction. I did a 5-week course at the National Computer Forensics Institute in Hoover, Alabama with the Secret Service to extract devices, and also teach it.
Okay. Are you intending to offer any opinions in this case related to digital forensics?
If necessary.
Okay. Are you here to give us an opinion about the extraction itself, to just confirm the extraction, or are you going to give some other opinion beyond the extraction?
I got to be asked the questions first, right?
I don't know. I imagine you've gotten prepared for this, and you have an idea of what you're here to testify to, sir?
I do.
Okay. Because I don't have any kind of report from you or anything, or any kind of, that I'm aware of, any kind of specific report.
Objection, Your Honor. The extraction report is the report, and that was provided years ago.
Okay, if that's fine. If that's the basis, that gives me the right direction. Okay. So let's talk about the report itself. You, in your studies, are familiar with some of the issues with Cellbrite, right? Some of the public criticism of Cellbrite.
Elaborate.
Are you familiar with any of the criticisms of Cellbrite and its use in criminal investigations?
Oh, there's criticisms on a lot of things. I mean, people have opinions on things. I'm not sure what you're asking.
Are you familiar with any of those criticisms?
I'm familiar with, people, sometimes it's too slow and it takes a long time to open. And
Are you familiar with the criticisms related to its reliability, sir?
I'm not familiar with them.
Are you familiar with criticisms related to the inability to recover certain deleted items?
Am I familiar with?
The criticisms related to the fact that there can be deleted material from a phone that the Cellbrite program will not allow to be recovered.
That's not necessarily would be an accurate statement because it's not necessarily the Cellbrite that's not able to recover it. There's too many variables within that would consist in not being able to recover data.
Okay. You'd agree with me, wouldn't you, that in terms of, there is, one of the other criticisms is that Cellbrite can be manipulated, right? You can manipulate the extraction. Agree with that?
Anything can be manipulated, but it's forensically sound through hash values and matching values to be able to ensure that that data is not manipulated or changed at all.
So when a piece of evidence gets into a digital forensics expert's hands, they have an opportunity, they could manipulate that evidence before it's extracted.
It would take a lot of, it would be extremely geekified and able to do it.
Okay. But an expert would have that geekified intelligence.
Possible, but not probable.
Okay. Okay. All right. How about this cross-validation? Did you do anything in this case to cross-validate the extractions that you performed?
I did. I validated the information by going into databases and looking at the actual information and being able to look in other softwares too.
Okay, now I want to make sure I understand this. Are you telling me that you looked at every image on these phones?
Absolutely not.
Okay. All right. What did you review? I
reviewed different things that were evidentiary value that were brought to me from the detectives.
Okay, so you looked at cherry-picked portions of the extraction, is that what you're telling?
I validated it.
Okay, so I just want to understand what was going on here. They give you a portion of an extraction, and then you would go, is that what you're telling me?
It's impossible for me to know exactly every detail of an investigation. That's what the reader is. It's a force multiplier. So in an event where there are massive amounts of data in a cell phone, and being one person being able to go through that, it's not just. You can't do that. It's designed to be a force multiplier so many people can collaborate and be able to come up with the evidence that is needed in the case, and then it is validated by me.
Okay, so we're in agreement that in terms of whatever evidence, if this evidence is in its pure original form, it is too voluminous to even be studied in completeness.
Objection. What evidence? I'm not really sure.
The extraction. You hear that?
But that's why it's categorized and used into the self-write reader, so it's able to be viewed.
Okay.
If you're looking at it as on a computer with a folder and you're trying to go through it by looking at folders, you will never be able to get through everything. Apps are sandboxed, so everything is, within its own app. So that's where the Cellbrite software is able to parse it, categorize it, and make it where you can read it, and you're able to search.
And do you have any? Is Cellbrite software something you have any control over?
Control as.
I'm sorry. Do you know the methodology? Have you been involved in any way, shape, or form with the software Cellbrite, other than using it in terms of like its creation?
No.
Okay. Any of its algorithms? Cellbrite will not share that. Isn't that correct?
It's proprietary.
And so you're having to put your confidence in the actual software and program, right?
Mm-hmm.
You can't independently verify that the program itself is not flawed.
That's not true.
Okay, that's not true. I'm asking.
Yeah, you can go. I can validate the information. You can use. I can go into the databases and make sure that it's reporting the correct information.
Okay, but you can't validate the software itself, right?
That is validating that the software is doing what it's supposed to do.
Okay. Well, the software gives you a product, right? An extraction.
Mm-hmm.
Okay. How can you validate it?
I can look at the device.
Sorry.
You can look at the device, but I mean, it's large, yeah.
Okay. So it is extremely difficult, would you agree, to cross-validate the device?
No.
You can cross-validate it in small portions. Is that what you're telling me?
No, I can generate a hash for the entire extraction. And that's what Cellbrite does, is it'll generate.
Objection, Your Honor. I'd like him to allow the witness to answer the question. I believe Lieutenant Wells was still talking.
Finish your answer.
Well, hash values are a fingerprint. What this does, it's an algorithm. There's certain ones, MD5, SHA-1, SHA-256, and these are basically fingerprints of the entire extraction. And they are generated, and as long as they are any type of manipulation, any type of change whatsoever to that, will completely change the hash value of the extraction. So that's how we ensure that evidence hasn't been manipulated, and that what we're working with is correct.
Okay. But the body that might be potentially manipulating it, the agency or the department, is you guys are the ones who extracted this. And this wasn't sent to a third party to verify the extraction. You were doing it in-house, correct?
I don't understand what you mean third party. Technically, I am a third party. I mean, I'm with the sheriff's office. This was a police investigation.
Okay. So you're not SLED, right? Like, DNA sample, we send it over to SLED. Is that
Correct.
now, you've been qualified how many times?
Twice so far.
Okay. And what were you qualified as in those two cases?
I was qualified as an expert in digital forensics, and I was qualified as digital extractions. I think it was digital extractions.
Okay. And so those are two different subsets of qualifications. Is that what they're telling me?
The digital extraction would be part of digital forensics. So the first time I was qualified would have been digital extractions, and then the digital forensics encompasses all of that.
Okay. Let me just make sure I understand. Digital extractions and digital forensics, which one's the big umbrella?
Forensics.
Forensics, okay. And you've been qualified as an expert in digital forensics one time?
And one time for that, yes.
And then a second, and then one time for the smaller category of digital extraction?
Yes, sir.
In the case where you were qualified as an expert in digital extraction, what program was used in that case for extraction?
Celebrate.
Have you ever been denied?
Have not.
Have you ever testified in federal court?
No.
Were you qualified in the 15th Circuit as an expert?
I was.
And in those two instances, what was how many phones were you asked to extract in those cases?
I don't recall.
Your Honor, I believe, based on his experience, I would move to strike this witness as an expert.
All right. I find this witness to be an expert, still busy with the limit, so we begin this again.
Thank you, Your Honor.
Did you extract data from at least one device in this case?
Yes, ma'am.
Was that, well, actually, let me just. Your Honor, if I may approach with admitted exhibit 19. And actually, let me give you the extraction also. I'm approaching with State's Exhibit 92, which I would ask to be marked for identification only. Admitted for identification.
May I refer to my notes?
Your Honor, may the witness refer to his notes to verify that that is the phone.
Yes, this is the phone.
Okay, just make sure you keep your voice up, please.
Yes, this is the phone.
Okay.
The device.
And how are you verifying that?
Well, first of all, each device has a unique identifier, which is IMEI, International Mobile Equipment Identifier. Our identity.
Slow down a little bit. We're trying to type everything down.
Sorry. And that's basically a unique identifier for the device, which I cross-reference that with the report that's in front of me, or the pictures that are in front of me with the device. I have documented pictures of when I did the extraction, and I verified that the IMEI number is the same.
And so is 92 the extraction of data that you performed from State's Exhibit 19?
Yes. And
Did you just, yeah.
yes, it is.
And how are you verifying that that is the extraction that you performed?
I validated before court and initialed this.
Thank you. Do you need to keep this in front of you just so you're sure what we're talking about?
Yeah, that's fine.
Is there a phone number associated with that phone?
Yes, ma'am, there is. 1513-252-4742.
Okay. So the area code is 513, you put the one in front of it?
Yes.
Okay. Are there any unique personal identifiers associated with the phone? So not the IMEI, but other identifiers?
The owner's name is Mouse, and I believe this was also backed up to a MacBook Pro with the user of Meagan Jackson.
Where did you get that phone?
It was given to me by Horry County evidence.
Did they also give you the password to the phone?
Yes, they did.
Were you able to extract data from the phone? Well, obviously you were able to extract data because you've identified that already. When you performed the extraction, did you add, change, or delete any information?
I did not.
What did you do once you performed that extraction?
Once I performed the extraction, I took the extraction and I parsed the data into a physical analyzer, which is the program to categorize it to make it more easy to search.
Did you then provide that to the solicitor's office for disclosure and discovery?
I did.
Were you asked, I'm going to jump ahead one second, were you asked to examine that extraction and another extraction for specific content?
I was.
Was that other extraction that you were asked to review done by Sergeant Marcus?
Yes, one of them was.
I'm approaching with admitted exhibit 95. Is that the extraction of Erica Dontell's phone that you reviewed?
It is.
How are you recognizing it?
I recognized my signature or initials on the jump drive before or after I reviewed the content.
Now, I think Mr. Britton covered that those extractions are fairly voluminous. So for the items that you were asked to examine, did you prepare excerpts of those voluminous reports?
Yes, I did.
So were you asked to examine, let's start with Exhibit 95, the extraction from Erica Dontell's phone. Were you asked to examine that extraction for any information on her phone of someone trying to expose the affair between the defendant and Christopher Dontell?
I was.
Did you find any?
I did.
And before I get to your first excerpt, does Cellbrite categorize data in much the same manner as your actual phone? So it would separate, say, photos, calls, messages?
It does.
Your Honor, I would object this being reduced. There's bigger evidence on this.
Was this identified?
Exhibit 98, Your Honor, is an excerpt of an already admitted extraction.
And I'm back. I'm sorry about that. Everything went frozen and I couldn't get it to unfreeze to even start it over again. But I'm back. Sorry, guys. I'm so sorry. I have to figure out how to get more. I don't know if it's RAM that I need. I've got an external hard drive. It's not that kind of memory. I think it's the RAM. I need more RAM. I don't know what's happening. I don't know if that's what it is or not. Everything else is shut off. Nothing, to my knowledge, is running other than Chrome. I don't know. Okay.
And, I'm sorry. Can you describe what exhibit 98 is?
This is a excerpt from an instant message conversation.
Your Honor, I have verified the extraction. May we publish exhibit 98?
Yes.
And so what, are you able to tell what program was used to send these messages?
From the party, it's registering as contact@textforfree.net.
Are you familiar with Text for Free?
I am.
Can you describe to the jury what it is?
Text for Free is it's a texting application that you can use if you don't have cellular service. It's used to be send text anonymously to where it can't be brought back to you.
Okay, you want to zoom in? Does that show when the first text was received?
Yes, the direction was incoming, so it came at 9/27/2020 at 3:35:27 p.m.
And what is that first text?
Your number is posted on the special ed curriculum. I thought you should know. I found out your husband has someone else pregnant.
And what's the next text?
The girl that is pregnant is Meagan. Ask her. Then redacted.
Let me go back to the first text that was sent at 3:35 p.m. And I'm going to show you. Your Honor, I'm approaching with State Exhibit 156. Is that an excerpt of the extraction from Erica Dontell's phone showing a reaction to the first Text for Free message?
Yes.
Your Honor, this time I would move to admit State Exhibit 156 and publish it.
Yes, sir, Your Honor.
You say yes.
Yes, sir, Your Honor. Yeah, yes, sir.
Text exhibit 156, admitted to the evidence without objection.
And this again was from Erica Dontell's phone.
Yes, ma'am.
Is there a date and time stamp for that first text message, this needs to move as fast as possible, we have an emergency.
Yes, ma'am.
And what is it?
I'm sorry.
What is the date and time stamp?
9/27/2020 at 3:40.
So about 5 minutes after that first text for free text?
That's correct.
Let me go back to, is it immediate? After that, first text at 3:35, did text continue to come in from the text for free app?
After the 3:35, yes.
When was the next one?
5:45, 23 p.m.
And what does that text say?
The girl that is pregnant is Meagan. Ask her, question mark.
When did the next text come in?
The next text would have been at 7:25 on 9/27.
And what does that say?
Meagan Jackson, Chris Dontell, Savannah Rice, Josephina Nakawatsa, flight 4652 Myrtle Beach, September 24th, 7:01 a.m. Flight 1944, Jacksonville, 10.
What was the next text?
Next one's 7:25:25 on 9/27. Ask her neighbors how often his. It's cut off on this one.
And why would the text message be cut off like that? Why weren't you able to recover the whole thing?
Well, this is in a timeline, so it would have cut it off. It could have. There's a lot of different reasons that it couldn't have pulled it.
What's the next text?
It's a link for https://idb.co/BQHR82R.
Okay, and what is IBD?
IBB is a image hosting site.
What do you mean?
Well, if you want to share an image or without directly sending the image, you can upload it to the site. It'll create a link for you, and then you can just send that hyperlink.
Did you, in fact, follow that link or type that link into a browser and try and pull it up?
I did.
Are you just identifying it?
I'm trying to admit it.
You don't have a hard time reading it. It's just difficult for me to see the prints really small. You know what I mean? I mean, it's, you know, so that's the jury to decipher this. I can't read it. Give a, let me see it.
You know, I'm going to approach also 90B, which is from someplace else without forecasting my question, but this version is easier to read.
Okay, that's the thing, this is so small.
Right, but this is from the website. This is from the website, so we can't control the font. 98A is from the IMGDD website, so that's how it pulls up. We have no control over the clarity of that,
But I mean, if I can't read it, how can the jury read it?
because this is the same conversation, and you can match up the readable portions of the blue portions here, and take
Okay.
the ones that are difficult.
So 98B
B,
is just a larger printed form of 98A.
from a different source. It'll be clear after I ask my questions, but,
Well, let's profit it.
okay, all right. I'm just gonna give you 98A and 98B. All right, so is 98A the image that you accessed using that IDB link?
It is. It is.
Just have to say that out loud. And then, were you able to find that same text conversation in the defendant's phone?
I was.
Is that what's depicted in 98B?
It is.
And how are you able to tell that it is the same text conversation?
Well, I can actually kind of turning over B. I can read it. I make it a point of spending time with you, and I love spending time with you. I like to have sex with you. I make it a point of avoiding Erica, and she makes me sick. And I don't have sex with her. There isn't a comparison. So I can actually identify the first text message, and then when I come to the report, or
And Your Honor, if I may, can we pull up the digital version of 98A? Ms. Waller has it on her computer, and it appears more legible than the printed version.
Well, I mean, how do I know that that's that? I mean, 98A, I'm looking at it, and I can see the first thing, the dark blue, it's printed in light blue, I can't.
What, will you be able to tell it?
Your Honor, we'd be able to.
Hold for a second. You're gonna have, I mean, I don't have any problem with the way, with the proper testimony.
I understand. The only problem I would have with proper testimony is I don't really understand, but maybe it's just me, where he is claiming that message, whether he was just reading involved sex, where it came from. Because that sounds like it's not part of the extraction, which is what he was qualified to testify about.
Well, I understand the second one, 98B, came off the first vote.
Right,
That's
so,
supposed.
I didn't mean to interrupt you, Your Honor. So, Exhibit 98 was the text-for-free texts that were sent to Erica Dontell. One of those texts contained an IDB link. So, in order to show that that text conversation existed in the defendant's phone, Lieutenant Wells just typed in that link, like anyone can do. Like, this is what you would get if you typed in that link. And it pulled up that photo of the text conversation. Then he looked for that text conversation on the defendant's phone. Does that make sense?
Yes,
So that's sort of what we're trying to prove.
I understand.
I don't be disrespectful, but I feel like you should excuse during this conversation.
I'm gonna go ahead and I'm gonna allow it.
Hold on, could I just be heard on it? I think what they're trying to do, as I'm hearing on now, and I think it's extremely prejudicial and very misleading. They're attempting to say that Meagan Jackson sent the anonymous message to Gregory Rice through this conversation, which is about sex, which is unrelated. And that is extremely misleading and improper.
Well,
I'm gonna know, but I'll allow it.
Okay.
thank you.
Could I have some time to try to read that myself?
We're also trying to reprint it, but if you wanted to load on these computers.
You can definitely read one.
And John, just while I'm having a chance here, just for a break, this isn't anything in terms of a confrontation clause issue. This is not a position. Nowhere in their report have we ever been provided any kind of summary or conclusion or idea that that was sent by Meagan Jackson, that the anonymous message was the imagination of Meagan Jackson. That is a new position they have taken at the start of this trial. And now they've come in and qualified an expert to try to link that without her having any opportunity to confront that. It's completely improper.
Overruled by the law.
Okay. Thank you, Ron. May I go approach this computer for a second?
We need to take a break or anything before we bring the jury back in.
Yes, we're just trying to print it downstairs so that it's in color, perhaps on readable.
It's just a better printer. I think it'll come out clear, Your Honor.
How long will the break need?
5 or 10 to be safe, I would say, Your
All
Honor.
right, let's take a 10-minute break. We'll come back. Dr. Wells, you cannot discuss your testimony. Okay?
Yes, Your Honor.
All right. We'll break for 10 minutes.
Do you have one or not? Yeah, otherwise I can work with you this afternoon. Your Honor, would you like me to replace the, well, I'll label this also as exhibits 98 A and B, or I'm not sure how to. Well, I mean, I guess we can figure that out later, because we'll be projecting the digital version, which I think is more clear, and that's what's on here. And then
Waiting for the jury to come in? What are we waiting for?
It's a,
that's perfect. Okay. So this line 8, just because we did take a long break, can you explain IBB.co again for the jury?
IBB.co, it's imgbd.com. It's
Slow down a little bit.
it's a web hosting for images. You can upload an image, it'll create a link to be able to share it.
Do you know whether those links are ever duplicated? In other words, would two, okay, you're answering. So there would not be, say someone uploaded BQHR82R, and then do they have the ability to take it down?
Yes, they can. I believe it can be taken down.
And then if someone else uploaded an image, would that file name ever be reused?
No.
So looking at line 8, did you go to that link, 8ibb.co, with that file name?
I did.
Okay. And is that what's depicted in 98A in front of you?
It is.
Your Honor, I would ask that 98A be admitted.
Yes, sir, Your Honor. States exhibit 98A, admitted into evidence without objection.
And may it be published, Your Honor.
All right.
Okay. And so down here where it says image link, what is that?
The image link is the address, basically the same as the web address. It's the web address for that image
So
and the
that's the
page.
link that was contained in the text for free text?
Yes, that is.
Okay. Can you show the text itself? And then zoom in a little bit. You're making your Were you able to find this same text conversation on the defendant's phone?
I was.
Is that what's depicted in 98B that you have in front of you?
It is.
And Your Honor, at this time, I would ask that 98B be admitted and published.
Any objection? Yes, sir, Your Honor. 98D, State Exhibit 98D is admitted into evidence without objection.
We'll go page by page, just so, let me get that. All right, so what is this first page of 98B showing you?
This first page is, there's multiple extractions for multiple devices. This is just identifying the device that the information came from.
And so which device did this come from?
This would come from the phone number 513-252-4742 and the IMEI last 5862.
Right, is that, and there's no spec, so is that the defendant's side?
It is.
Yes?
It is.
Okay. And, okay, no, just the first couple holes. So, and is this, are you able to print out text conversations sort of in different formats from cell, right? So like this is, I always call it the bubbles,
Yeah.
because I like the bubbles better.
Yes, ma'am.
Okay. And did you compare this text conversation in 98B with the one in 98A?
I did.
And they appear to be the same?
They are.
And what is the date of this text conversation?
9/15/2020.
So I can. That's just a big which extractions on to this is Your Honor, if I may approach with State's Exhibit 100. Did you look through the extraction from the defendant's phone to see if there was any, I'll call it IDB or IMDB activity on her phone?
I did.
Did you see any evidence of such activity on her phone?
I did.
Is that what's depicted in Exhibit 100?
It is.
Is that an excerpt from the full extraction?
It is.
Your Honor, I'd ask that Exhibit 100 be admitted.
Any objection?
Yes, sir, Your Honor.
State's Exhibit 100 admitted into evidence without objection.
May it be published, Your Honor.
Yes.
Okay, can you just explain to the jury what they're looking at?
In the readable format, it puts it, you'll see where types is, that it came from the notes application.
Is that this?
And I'm sorry?
I was just showing, because some jurors are looking over here, so.
Oh, I'm sorry. So the event is that is the contents within the notes, and this is a list of different IBB.co web pages and web addresses.
I'm sorry. Okay, did you then, does this tell you when that list was created?
On 27/01/56.
And what does the modified date and time mean?
It's whenever the created date was whenever the actual file was created, but the modified could be when it was changed or deleted.
Did you then go to each individual IBD.co link to see what was there?
I did.
For some bullets. Sorry, I remember. Quite a few links. When you went to those individual links, Did you create exhibits of each link?
I did.
Your Honor, Your Honor, you see I've been handed a pretty decent number of exhibits. I'll take the best of them, which is, I just want to keep everybody away.
But these are simply those links that were provided many years ago, just plugged into the search engine.
Your Honor, just my initial, without going through each one of these, each one of these is, there's no date on these documents. I don't know what date this is pretending to have been from.
How are we identifying those?
Your Honor, so that would be 100 A through S, I believe it is. And each exhibit corresponds in order to the IDB.co files that are listed in that notepad.
But I just want to make sure I understand, is it the testimony that says created on 9/27/2020, that all of these were created on that date? Is that, anybody? Okay, yeah.
She's just showing you what she's getting ready to show the witness and have them testify to it.
Yeah, Your Honor, unfortunately, there's some things we need to take up outside of some jury victims. You know, I hate it.
All right, ladies and gentlemen, we'll let you back to the jury room, and notepads in the box.
Yes, sir. It appears that from that the testimony going to be either all created on 9/27. I don't know if that's accurate or not. Two, as I'm looking through this, there's some there's some protest stuff in here. For instance, ultrasound images and the way those things are discussed related to abortion. Again, I had longer money ago just to.
We'll go through all of them and let me know what your objections are.
Thank you, Your Honor.
Just bring me the ones that you object to.
Okay, thank you.
Now. I'm trying to pay bills, y'all. No multitasking. Can't even say it. I'm multitasking again. What are we waiting on?
100A2 through 100S2 are essentially the same images, but retrieved from the defendant's phone. So it's the same images, just showing that these images that were uploaded to IBD, were created on the defendant's phone.
All right. Anything further from the defense before we bring the jury in?
If you want to hear me now on the foundation plan, or should we try to lay that? She laid the foundation, didn't
She hadn't laid the foundation yet, no.
I'm just not general objection to it under rule 4.
All right. Anything further from the state before we bring the jury in?
No, Your Honor.
All right, let's bring the jury in.
None. Oh, it's opposite. This ought to be.
All right, ladies and gentlemen, welcome back. Make sure you have your own letter cards. All right, you can continue with direct examination.
Thank you, Your Honor. Let me just go back to this. So you went over that this shows that it was created on September 27th, modified on 10/2. First of all, what is the significance of the date of October 2nd in this case?
That'd be after the crime.
Pardon?
Be after the crime.
The date.
The day of the crime.
And then the modified date and the fact that it's showing deleted and trash, what does that mean?
That's most likely, that's the way it was modified and the file was moved to the trash.
Now, when in the course of your analysis, review of these items, did you go to each individual IBD.co link?
I did.
Did you create printouts of what you found at each link?
I did.
If someone went to that link today, in all likelihood, would that image still be there?
It will.
Your Honor, at this time, I would like to approach with exhibits 100A through 100S. If you can review those, please.
Yes, ma'am.
Are those the printouts that you created from each of those links?
They are.
If we can start with 100A, please.
Wait a minute, is that what we do that?
Oh, I'm sorry. Thank you, Your Honor. Thank you. Your Honor, I would move for revision of exhibits 100A through 100S. I apologize.
All right, states exhibits 100A through 100S admitted in the evidence of the defendant's objection.
Your Honor, may I just take one more objection? I hadn't had a chance to take that. I want to refer to have a chance to lay the foundation. This says created on 9/27. This witness cannot and has not testified to the date those images were actually created. That is not an accurate date in terms of creation of those documents. And he can't, it's impossible for that to be true.
100A through 100S admitted in the evidence of the defendant's objection.
Okay, and just to clarify, then, created date, is that for the notepad entry?
Yes, that would be the date that the note was created, not the links.
Okay, so let's, may I publish them, Your Honor? I apologize.
Yes.
100A, please. Okay. So, can you just explain what we're seeing here, and especially the bottom part, if you need us to scroll down, I guess we can do that.
Use my little.
And you can use your pointer,
Use
and
my
that
pointer.
should show up on all the TVs. I think after you get it.
Yeah.
Well, use that one, it might be easier for you, and it'll show up on all the screens.
Okay. All right. This right here is from the link. If you can, your Honor, may I stand up for the screen?
All right, as long as you got it in your microphone, or the court can pick up the testimony.
This right here is the image link. This is the same as the link that is in the notepad. And this would be the file name. And The embedded code, this is the link, the HTML, where you would represent the web page or when you would share the document.
Sorry, I just need to, if I can refresh your memory, some different information. Okay. There is, next to the embed codes, well, I'll come over here, you point it there. There's something that says about. Does that have potential to give you more information about that image?
It does.
Okay, so we're going to page of this. Is this the information that comes up when you click that about link?
It is. This is exit data, which is,
Can you spell that for the word?
exit is EXIF.
And what does that mean?
It's actually data that is about the image. It's basically data about data. It contains things from the date and time of the original, the manufacturer of the camera, GPS coordinate location. So when you get that information, you can also go back and even tell, even up to exposures, whether the flash was on, and just a lot of information about the image itself.
So for 100A, does it first tell you, let's start with the date and time of the original.
The date and time of the original was 9/29/17/01/21.
So September 29 at 5:01, sorry, I have to subtract 12.
That's correct.
Okay. Does this tell you what type of camera took that phone?
It does.
Excuse me. What kind?
The manufacturer was Apple, and it was a model iPhone XS Max.
What is the model of the defendant's phone that you extracted?
iPhone XS Max.
Well, I'll go through all these incidents first, and then we'll just go through the next set. Where applicable, because you have the hard copies, if there is that extra data, just...
Can I go first, right, to see that? Is it okay if I send it here? Just want to go and see your receipt.
Just don't modify it.
All right, go ahead.
So if you can go to 100B, and as I said, if you were able to get that extra data, let us know.
I was.
Okay. And what can you tell us about this image?
This image is also one of the the image link was included in the notes. I can also say that it was the manufacturer of the camera that took this picture was an Apple iPhone XS Max, and the date and time of the original is 9/29/17/01/27.
And if you can just, sorry, can you say September 29th in the time? Otherwise, it's like a whole lot of numbers. I want to make sure we're getting the date and the time separate.
September 29th.
Okay. Just roll up to the cursor so they can see. Okay. And that's where you were getting that date created and that camera?
That is
information?
correct.
Okay. 100C. What can you tell us about this image?
Again, same, this is image link. The image was from the notepad on the device. And again, the manufacturer was an Apple. The model was an iPhone XS Max. And the date and time of the original is September 29th, 17/01/2020.
And just to save time, when you are giving us that information, that means that that third page is there?
Yes, ma'am.
Okay. 100D.
Also in the notes, this was an Apple iPhone XS Max. This was created on September 29th, 17/01/2020.
I have a lot of demand. I'm going to ask that you wait until the exhibit goes up the first. Sorry. Okay, what can you tell us about this?
It's also from the notepad and the link. This was also created with Apple iPhone XS Max, and it was created on September 29th, 2020 at 17:02.
100F?
Again, this is from the notepad, and this was also created with an Apple iPhone XS Max, and this was created 9/29/17/02, 2020, or September 29th, 17:02.
100G?
Again, from the notepad, this is an Apple iPhone XS Max, and this was created 17:03, September 29th, 2020. Again, from the notepad, Notes app, Apple iPhone XS Max, created on 17:03 on September 29th, 2020. Again, from the Notes app.
Present.
It's a manufacturer's Apple iPhone XS Max. Date and time is September 29th, 2020 at 17:03.
Jay?
Again, from the Notes app. Again, it was a Apple iPhone XS Max, September 29th at 17:03, 2020.
Okay, let me just pause you for a second. At the top of this photo or text message, there appears to be a phone number, correct?
Yes, ma'am. It'll be,
Do you know who that phone number belongs to?
I'm not sure, no.
100K.
$100K. That is also a link from the Notepad app or Notes app, and this also came from my phone XS Max on September 29th, 2020 at 17:03.
L?
Again, from the Notes app, and it's also an Apple iPhone XS Max. The date and time is September 29th, 2020, 17:03. Again, from the Notes app, Apple iPhone XS Max. This was at September 29th, 2020 at 17:04.
N?
Again, from the Notes app. It's also from an Apple iPhone XS Max. This was 9/29, or September 29th, 2020 at 17:04.
So far, pretty much all on the same day around the same time?
Yes, ma'am.
So,
Again, this is also from the Apple iPhone XS Max. This was September 29th, 2020 at 17:06. All right, again, from the Notes app, this is the Apple iPhone. It's from Apple iPhone XS Max. And date and time original was September 29th, 2020 at 17:06. Q is also from the Notes app. It was also an Apple iPhone XS Max. And the date and time original is September 29th, 2020 at 17:06.
R.
R is also from the Notes app. And it also came from an Apple iPhone XS Max on September 29th, 2020 at 17:07.
Last for this set, S.
Okay, this all came from the Notes app. It also came from iPhone XS Max, date and time September 29th, 2020 at 17:08.
Now approaching the 100 A2 through S2. Were you able to find each of those images on the defendant's phone, which was an iPhone SX Max?
Yes, ma'am.
If you could just look through those and tell me if those, I'll do it.
Okay.
Tell me if those are the excerpts of your,
Please.
you need to? Start looking those off. Where on the phone did you find the,
Safari.
can you explain what that means?
A temporary file it's where an application will store a file temporarily for it to use. It could be temporarily there until it's downloaded. It could be temporarily there when it's uploaded, but it's just a temporary holding spot for a file.
I think we can go through these a little bit more quickly. I'm sorry, actually, Your Honor, I would ask that 100A2 through 100S2 be admitted in public.
Your Honor, you can take a look at it. I just told the board to leave it for you. Yes, no question, asking you all.
talking to you guys, and probably better to have all at the same time.
I'm just going to check that, just in terms of, I don't know if there's a foundation laid for the timing of these creation of these documents. I don't, so I'll make that objection on it. Otherwise, you can, but I'm objecting whatever.
States that it's 100A2 for 100S2 or admitted evidence or defendant's objection.
And let me clarify one thing before we go through those. These photos are just the photos from the IBD.co links that were in the notepad, correct? Not from any sort of
Correct.
communication. Okay, so we'll try and go through this a little bit more quickly. And does each exhibit show when the particular image was created?
So far, yes.
This is my.
Yes.
Yeah, so what I'm asking is, can we just fast forward to the third page exhibit? Okay. 182.
This will be 5:01 p.m. on September 29th, 2020.
Sorry. There you go. Okay. And so can you just describe for the jury sort of like the layout of the screen and where you're finding created?
Okay. Right here, under images where is the timestamp, the capture time. It shows that this right here, this application ID right here, this long 7FE79950. If you will scroll up, please. It shows that that's the mobile application ID for Safari. Okay, scroll back down, please.
Sorry about that, guys. I'm trying to pay bills. My attention is diverted. I'm sorry. Trying to do everything at once again. Jill thinks I make it look easy. It's not easy.
B uses, it does throw in a couple extra hashes, but all the digits are the same and the hash mark.
Okay, and are these, when was this created?
This was created on 9/29/2020 at 17:01.
September 29th?
September 29th, 17:01.
Okay. B2. And if, just to kind of make this more efficient, if there is one where it's not in the temporary files, but I think you said they all were, but if we can just
Yes.
jump to the created.
Again, this one was in the same temporary folder, and it was created on September 29th, 2020 at 17:01.
See? No, C2, sorry. My fault, C2. When was this created?
Again, September 29th, 2020, 17:01, 41.
Also stored in the temporary?
Also stored in the temporary. The name is the same as the item beginning.
B?
Right.
B2. B2.
Again, same camera make, camera model. created on September 29, 2020, 17:01, and 50 seconds. Created September 29, 2020 at 17:02:01.
F. F for the record.
Again, camera make Apple iPhone XS Max, September 29th, 2020 at 17:02.
G2.
September 29th, 17:03, 2020.
H.
September 29th, 2020 at 17:03.
I. 2.
Created on September 29th, 2020 at 17:03:29.
J2.
Again, this is created on September 29th, 2020 at 17:03:36.
Okay. 2. J2.
September 29th, 2020 at 17:03:46.
L2.
September 29th, 2020 at 17:03:55.
N2.
September 29th, 2020 at 17:04:19.
N2.
September 29th, 17:07:29.
O2. So far, these are all being created within the span of 5 to 10 minutes, right?
Yes, ma'am. Created September 29th, 2020 at 17:06:01. (2020) at 17. Created September 29th, 2020 at 5:06:51 p.m.
R2.
Created September 29th, 2020 at 5:07:10 p.m.
Your Honor, I'm going on to another topic, so I wasn't sure if you wanted to break for lunch.
Yeah, let me do it right now.
Oh, I didn't do S? Oh, they did. I'm sorry, one more S too. I apologize. One more.
September 29th, 2020, 5:08:11 p.m.
Sorry, now I'm moving on to a new topic. You want to break?
All right, ladies and gentlemen, we're going to go ahead and break for lunch. We can go ahead and do results. We do have lunch in before we begin today. We'll come back about 2 o'clock and resume this. I'll discuss the case and move on yourselves. Have a good lunch and we'll see you back at 2 o'clock. right, stand treated.
I'm confused.
All right, ladies and gentlemen, welcome back. I hope everyone had your lunch. We're ready to resume the trial of the case. Make sure you have your own notepads and no one else's notepad. Ms. Walker, you will continue with the direct examination.
Thank you, Your Honor. Were you asked to examine the defendant's phone for other evidence that she sent proof of the affair with Christopher Dontell to anyone?
I was.
Your Honor, I'm approaching with State's Exhibit 135. Lieutenant Wells, you recognize that exhibit?
I do.
Is that an extract or an excerpt of the extraction report from the defendant's phone?
It is.
And, Your Honor, I would ask that Exhibit 135 be admitted.
All right, you're good.
Yes, sir, Your Honor.
All right, State's Exhibit 135, and then objection.
And Your Honor, may we publish it?
Yes.
Thank you. Let me know if you need more of the page shown, but can you tell, ladies and gentlemen of the jury, what this extract from the report shows?
This shows an account that was accessed, a Google account that's hgabe2210, and it's under the passwords where it is kept in a keychain where it doesn't necessarily show the passwords. It shows the encrypted version of a key, but this was created on 9/27/2020 at September 27th, 2020 at 6:47 p.m.
Okay, and so is this showing the creation of the account or the password?
This is just showing that it was accessed the account was accessed on this device. It doesn't show the creation time of the actual account.
Okay, and you're saying, did you say that the password is stored in a keychain?
Yes, keychains, not necessarily the actual legible key password, but it's in the keychain, P list.
Is that like now, it saves the password so that you don't have to fill it in every time, or what's the password keychain is?
That's Apple's secure place to store passwords, and if you own an Apple device, you'll see that you get the option to store things to your keychain, but the keychain P list still logs those entries.
So when was that account accessed with the stored password?
September 27th, 2020 at 6:56:47.
Okay, and then while you're looking at that, I'm just going to show you. Admitted 95, so you remember the extraction. Remember, I'm approaching with admitted exhibit 95. That would be previously identified that as the extraction from Eric Dontell's pen.
Normally, what I do is just seeing what's in the attachments.
If we're going to get to that, that's 99. I can't blow that up all.
Okay. If I can't identify what it is, can't read to it.
I mean, that's already in it.
No, 95 is that I showed them. That's the extraction. These are just excerpts from the extraction.
Okay. So how does that identify?
This is 99. All of the exhibits that Lieutenant Wells is testifying to are portions of the extractions that were turned over to the defense 3 or 4 years ago.
So you say that's part of
99 comes from 95. 95
is already in it.
Yes, 95 is the extraction from Erica Dontell's pen.
I don't have 95. 95 is not in it.
It was in K. Marcus.
I have those entered through Sergeant Marcus.
You're right.
Okay.
All right.
So 99 is simply a portion of 95.
All right. Oh, well, State's Exhibit 99 for minutes of day.
Okay. You're on.
Yes.
And so then, Your Honor, maybe we also publish it.
Yes.
Do you recognize Exhibit 99?
I do.
Is that, as we have been saying, a portion of the extraction from Erica Dontell's phone?
It is.
Okay, so can you tell what we are seeing here?
What we're looking at here
Not
is
easily.
an email. The subject is Chris Dontell affair. And in the body of the email, it is proof that Chris Dontell is having an affair with Meagan Jackson. Meagan is pregnant, attached is text and pictures the two have shared. And then under the attachments, there are 3, 6, 7, 8, 9, 10 images.
And then, what is the date and timestamp on that email?
October 1st, 2020 at 7:30.
Can you tell who the email was sent to?
There just was one, the Lori Vallow, Brandon, what was his name? Brandon Boudreaux or something like that. That was attempted, and he lived, but usually not. If there is one, though, I'll look. If there is one, we can do that.
There's a glare on the screen, sorry.
Read it from the exhibit.
It's Erica D'Angelo@gmail.com, Miss Dontell at gmail.com, Miss Dontell at gmail.com, Colton's mom at gmail.com, D'Angelo2 at Colton's mommy coupon, and Aaron at gmail.com.
Okay, and you said that that email contains a number of attachments.
Yes, ma'am.
Did you then go through and create or print out each of those photo attachments?
Yes, ma'am.
Did I ask you what account that what email account sent that message?
No, ma'am. But it came from
What email sent that message?
a,
Is that the one that the defendant's computer?
yes, these are the larger images of the images that are in the email, contain the attachments.
Sorry. Did you, as you accessed those photos, did you then look to see if you could find those same photos on the defendant's phone?
I did.
Did you find them on the defendant's phone?
I did.
Did you create exhibits that are portions of the extraction report from the defendant's phone showing where they were located?
I did.
Yeah, that's fine, no problem. I'm sorry, I'm adding to my order.
Your Honor, I'm approaching the witnesses 99A2 through 99J2. Do you recognize those as the excerpts of the extraction report from the defendant's phone that you printed out?
I do.
Your Honor, at this time I would ask that 99A2 through 99J2 be admitted in public.
Any objection?
No, sir, Your Honor. No, sir, Your Honor.
Statement goes 99A2 and 99A2.
And Lieutenant Wells, I'm going to do it a little bit differently this time, so I'll talk about 99A and then 99A2, so we're on the same image. Does that make sense? So can you start with 99A? Once it's up on the screen. Is that the first attachment from the HDA 2210 email?
It is.
And then going to 99A2. Okay. Does this page show where you were able to find that photo on the defendant's phone?
It does.
And does it show what date and time that image was created?
Yes, October 1st, 2020 at 7:26:51 p.m.
Going to, sorry, B2. Okay. Is that the second image? This is not an image. I don't That says H-5. Okay, I'm sorry. 99B, is that the second attachment from the email?
It is.
And going to 99B2, does that say what date and time it was created on the defendant's phone?
Yes, it was created on October 1st, 2020 at 7:27:11.
Is that before or after the HK email was sent?
This is right before. Yes.
You still have Exhibit 99 record, right?
No, that's a.
You should still have it.
Let me get it back to you. 9982.
There it is on the screen.
Yes, it was before the timestamp for the email being sent was 7:30. 24. Same date, October 1st.
Okay, we see C, 99C. Is that an attachment from that HCA email?
It is.
And C2? At what date and time was that image created on the defendant's phone?
Again, it was created on October 1st, 2020, 7:27,
Still before the email was sent?
roughly 3 minutes before the email was sent.
D? Is that an attachment from the HCA email?
It is.
And D2? When was that photo created on the defendant's phone?
October 1st, 2020 at 7:27:42 p.m.
99E? Is that another attachment from the email?
It is.
E2? What date and time was that image created on the defendant's phone?
October 1st, 2020 at 7:28:06.
F? 99F? Is that an attachment from the phone that you printed out?
It is.
Excuse me, the email. And then F2? What date and time was that image created on the defendant's phone?
October 1st, 2020 at 7:28.
Again, still before the email was sent.
Yes, ma'am. 2 minutes before the email.
99E. Is that an attachment from the HBA email?
It is.
G2? What date and time was that image created on the defendant's phone?
That would have been created on October 1st, 2020 at 7:28:53.
You may have to start speaking up a little bit because I think the sky's open outside. H, 99H. Is that an attachment from that email?
It is.
H2? was that image created on the defendant's phone?
That would be October 1st, 2020 at 7:29.
99I. Is that another attachment from the email?
It is.
99I2. When was that image created on the defendant's phone?
This would have been on October 1st, 2020 at 7:01.
701?
Yes, ma'am.
How many was there? This is the last one from this email. Is that the last attachment from that HD 2210 email?
It is.
Phase 2. When was that image created on the defendant's phone?
It was created on October 1st, 2020 at 7:29:47.
So essentially all of those attachments from the HDA 2210 email, did you find having been created on the defendant's phone prior to the date and time of the email was sent?
Yes, ma'am.
Did, sorry, I'll put the number. And there's the 99 before. Did you also examine the defendant's phone for relevant text conversations between the defendant and Christopher Dontell?
I did.
So the jury heard testimony about a package that Dontell intercepted and gave to the defendant. Did you find any text messages that seemed relevant to that?
I did.
I'm approaching with State's Exhibit 155, and if you can look at that and tell me if it is an excerpt of the extraction report from the defendant's phone relating to the package.
It is.
Your Honor, this time I would ask that Exhibit 155 be admitted and published.
Yes, sir, Your Honor.
I say exhibit 155 and maybe the evidence.
Please note. Can you read those texts, please? The text is a little small, and if you can say who the speaker is.
Okay. From the owner of the device, which is listed in the contacts as HMMMMMM. Go home, watch your mail, meaning your mailbox. I remember this one time he was, David Colson knows this, you want me to?
There's a curse, that's what he's just,
You're asking the question.
you can read it. I mean, you're not cursing at the court, you're reading the text.
I remember this one time he was fucking with his ex-wife. He wouldn't hesitate to put something in your mailbox.
What's the next text?
From the same. Plus, he texted me, which means he's off work. He should have had enough time to get to your house. I would watch it for the next couple of days.
And then who is the response? Is there a response to that?
There's a response from the contact 333-81 or 1844, which is Chris Dontell, that says, okay.
What does the next bubble say?
Also, I'd be careful with you not being home. He might stop by if he sees just her and knows for sure I'm out with you. If if it is him, chances are he'll have the balls to confront her if he's that pissed off.
Okay, and what is the date and time range of that text conversation?
This was on 9/28, or September 28th, 2020,
So
from
she's saying that Greg
3:53 p.m. to 3:58.
After seeing that text message about the package,
Okay, y'all, I'm sorry. I had to pay bills. So she's saying that Greg was going to go to his wife to expose everything. Is that what she's saying in the text messages to him?
did you find any relevant location data on the defendant's phone?
I did.
I'm approaching with State's Exhibit 101. Is that a portion of the extraction from the defendant's phone with relevant location data?
It is.
Your Honor, at this time I would ask that Exhibit 101 be admitted and published.
Meagan Jackson.
Yes, sir.
So you did it 101, you never did that one? Okay.
Let me just scroll down so you can see. Yeah, like that. So can you tell me what lines 1 and 2 show?
This shows a location from her device in the native locations. It's in the SQLite database write ahead log, and it has GPS coordinates of where the device was, and it was where the device was, and it was visited, and it gives a time it was there until.
Sorry, I'm just going to step over here. So that's indicating that it was visited,
Correct.
and then is this the time? So September 30th from 1:34 to September 30th of 209? Actually?
Correct.
In the position column, what does that indicate?
That is the latitude and longitude of where the device is.
You can now scroll down to the next page. What does this line 3 show?
This is a location data that comes from a search in Google Docs, or I'm sorry, Google Maps, that searched the name FedEx Office Print and Ship Center, and it returned back the GPS coordinates.
What is in the last column? And I'll have Riley scroll back up so we can see what the heading is.
That is whether it has been deleted or not.
So does the yes indicate that it was or was not deleted?
It indicates that that record was deleted.
Did you then run those GPS coordinates just through Google to try and find what was there?
I did.
I'm approaching with 101A and 101B. Did you create printouts from the internet of what's at that location, those locations?
I did.
Are those copies of what you found on the web?
They are.
Your Honor, this time I would ask that exhibits 101A and B be admitted and published.
Meagan Jackson.
Yes, sir, Your Honor.
I said exhibits 101A and 101B.
All right, so what does 101A show?
101A shows the GPS, the latitude and longitude, and a pin of where that, when searched, that latitude and longitude came up.
What was at that location?
This one is a FedEx office over off Seaboard Street.
Courts and motions for a moment. Perfect. Can we go to the second page of that? Into that? Just scroll. Was that also just from the Google Street View?
It is.
Okay. We can go to 101. Was this from the second set of coordinates?
It is.
What's at that location?
The UPS store package ship.
Okay. Did you examine the defendant's phone for any text conversations where she might have suggested that Greg Rice revealed the affair?
I did.
should say, did you find anything that seemed to suggest that Greg revealed the affair?
I did.
Did you create an excerpt of the report showing what you found?
I did.
I'm approaching State's Exhibit 153. Is that the excerpt that you prepared?
It is.
Your Honor, at this time I would ask that State's Exhibit 153 be admitted and published.
Yes, sir, just under the rule of completeness, Your Honor, we're getting excerpts here, and that's okay to some extent, but if we'd like to have the complete conversation from these dates included for the jury's consideration.
On cross-examination, you can put in the entire conversation.
All right, thank you.
All right, State's Exhibit 153, admitted into evidence over defendant's objection.
And can be published, Your Honor?
Yes.
Thank you. Can you read this text conversation, please, including who it's to and from?
This is from the same HMMM, the owner of the device. Just talked to Greg. You busy? The next, he goes, okay, well, she goes, okay, well, Greg does know I'm knocked up, and he said he would tell Erica to her face if he got the chance, but he had said he hasn't yet. He also said it's not him texting, and then just tried to make a cover for himself when he talked to Savannah. From the 1844 number, which is listed as Chris Dontell, double homicide from the owner. It'll lie. He doesn't care, and he has enough proof.
And what is the date and time on that text conversation?
It will be September 9/27, 19 p.m. on the same date.
Did you also search the defendant's phone for text messages that indicated a potential plan to harm Greg?
I did.
Did you create an excerpt of the report of the relevant evidence that you found?
I created an excerpt, yes.
I'm approaching Your Honor, State's Exhibit. State's Exhibit 151.
Yes, ma'am.
Is that
This
the
is.
excerpt that you created? Your Honor, this time I would ask that Exhibit 151 be admitted and published.
I'm sorry, would you respond to this excerpt? Any objection?
Yes, sir, Your Honor, this is impermissible character evidence, subject to Rule 404.
Can you hand it up to the judge? Just show me the text.
Big blue box, no banker's boxes.
There had been some testimony about a text from the victim to the defendant about a storm coming. Did you search for that conversation?
I did.
Were you able to find a relevant text conversation?
I did.
Did you create an excerpt of the extraction from the defendant's phone showing that conversation?
I did.
This is not being admitted this time, is that right? Or are you trying to do it now?
I am going to try and admit it through Lieutenant Wells.
Yes, this is, at this point, your identification, you're not submitting it in this minute.
I'm showing it to you in this moment so that you can see it.
I'm
and
going to
then
have some objections, is all I'm saying. I'm going to have some objections to this document going into evidence under the same rule we just discussed in the other 404.
Your Honor, I'll show you State's Exhibit 157. Again, this is an excerpt of the report that they've had for years.
Come on, we're almost done with this day. I get to keep going up the sidebars. Bad as can retrial.
I'm showing you State's Exhibit 157. Is that the excerpt from the data extraction from the defendant's phone showing a text conversation that includes a reference to a storm is coming?
Trying to find what page it's on.
Your Honor, can you just talk about that?
I think it's the last page.
Okay, yes.
Is that an excerpt that you created?
It is, yes.
Your Honor, I'm sorry, I'm double checking to make sure. But I would ask at this time that Exhibit 157 be admitted.
United States Exhibit 157 is admitted in evidence over the defendant's objection subject to the redactions that we discussed.
And Your Honor, just to be efficient, I can have him start reading this, but I want to just. And who is this text conversation between?
From 1-843-650-150, which is G, and the owner,
Letter G?
and the owner of the device, which is the XS Max.
Okay, you're gonna have to speak up.
All right.
There you go. Can you start at the top of the conversation while we're waiting to complete the redactions and just say who is sending the message and who is responding?
From G, is it okay to come and get the kids? Reply, they are not home from school yet. G, okay, then I'll go home, take a shower. Thanks, just text me when they're ready, please. Hope your day is going well. The owner, kids home, just text when leaving.
And just for clarification purposes, the owner of the phone is Meagan
Meagan
Jackson.
Jackson, yes.
Oh, he's so nice. Hope you're doing well. And she's like, kids.
Actually, to G, actually, they can stay today and tomorrow since no school tomorrow. From Greg, well, I haven't made it home yet, so I can just head that way. It'll be about a half an hour when I would arrive. She replied, okay, that's fine. Stay or wait till tomorrow. Either way is fine. Greg, I have no problem with them spending the night tonight and tomorrow if that's okay. Reply, that is fine. When can you, Greg, when can I pick up the kids? I hope your day is going well. She replied, I'm on my way back. I left this morning for a call in Aner and haven't been home yet. They've been giving Savannah a hard time and trashing things. As soon as I go home and make them clean up their mess, they can go. Greg replied, he just text me, hey, just text me, please. She replied back, okay, you do have a better or more cooperative dick when you're high. From Greg, WTF. from Ms. Jackson to Greg, that was not supposed to go to you, nor was it supposed to come out like that, so I'm glad you got it. It was supposed to say more of a dick and not a cooperative. From Ms. Jackson, if you can pick up kids by 5, I have a body in NC waiting for me to pick up. I need to leave by 6. Hello? Is that okay for that time? Again, I have to let Chuck know.
Those were all from the defendant?
They were. At lunch. To do anything today, and I don't really care. Had you not got them today, they would have had dinner and straight to bed. Dakota took part 2. She pissed in cups and had the dogs drinking. He replied, well, where else is she supposed to piss when Savannah doesn't let her out? And it's quite apparent that you don't care. From Ms. Jackson again, excuse you. As soon as I walked in at 4:47 p.m., she asked, and I said, you're leaving in 10 minutes. Wait till you leave. This was when Savannah had her out with the other 2 cleaning the upstairs, so she wasn't even in her fucking room. She made her go back in the room after she went into Savannah's room and took her shit and messed stuff up. So go ahead and run your fucking mouth again. Greg replied back, okay.
What did he say?
She also said, she texted back, also, Blake was told not to let Rocco out while you were here, and he could give 2 fucks less and let him out anyway. Greg replied, okay. From Ms. Jackson, you know it doesn't matter how many fucking days I take off and spend the day with them. The second that I actually have to work, they turn into little assholes. I don't know if that's because I let them go back and forth between my house and your house and things aren't the same, or if they all just need to go to fucking boot camp.
Oh my God.
Just got to this again. This is Ms. Jackson.
She reminds me of my husband's ex. One day, we had plans to go to Epcot. And Rick Springfield, who when I was a kid was everything to me, posters all over my wall, watched General Hospital when I came home, like off the school bus, beeline to the TV, like threw my book bag on the couch, didn't even go to the kitchen for a snack, go to pee, nothing, like TV on, Rick Springfield. Never got to see him in concert as a kid. He was at Epcot. Finally, my dream come true. Travis and I are ready to walk out the door. His ex-wife calls. We're in Mulberry, which is in Polk County, which is like an hour maybe from Epcot, where Rick Springfield is going to have a concert. So excited. She calls. I'm in Lakeland. Come pick these little bitches up. I'm sick of them. I was so mad. Never been. She lived up here. This is how I met Travis. Her sister fixed me up with him when he was visiting for Thanksgiving. So mad. Who does that? Because her sister lived in Lakeland. She was visiting her sister and was just like, come pick these bitches up. I'm so sick of their faces. Like, totally ruined everything. If it had been my ex, I would have said no. Absolutely not. You didn't give me advance notice and I have plans today. But does Travis do that? No, because you don't tell that woman no. She doesn't take no for an answer. And she would have pulled out, oh, but you don't get them every other weekend and whatever else you're supposed to get them. Yeah, but he didn't get them because she didn't let him have them. Okay, I'm sorry. I'm getting hot. She reminds me of my husband's ex.
Just got to reception again. Me and Savannah broke down in Asheville. Chuck's sending us another driver. The van won't be fixed until tomorrow. From Ms. Jackson, you can call Chuck if you need to, but we won't make it back till tomorrow. and going to miss our flight today, so trying to figure out how I'm going to make it to court Friday. Greg replied, funny, because the kid said you were leaving this morning. Once again, I don't heed people's warnings that warn me you were going to F me over again and do this asterisk. But I love my kids so much, I want to be with them all the time. From Miss Jackson, we were, or supposed to leave this morning. It was 12:50 we leave and wouldn't get there till 5:29. I just lost $2,000 in plane tickets. Thanks for being an ass about it. From Greg, okay. Oh, but I'm going to lose my asterisk job because I have nobody to watch my kids. So no thank you. Miss Jackson replied back, call Chuck. It was not planned. I'm losing two days, like I said, and I still have to get to Ohio.
Dang, how far they go to pick up bodies?
From Greg, why would I call Chuck? Is he going to watch the kids for me? I'm right down there. It would have been a nice to get a call last night or whenever instead of right before I walk out the asterisk door to take the kids to your house. How convenient. She replied, thought I would make it back, didn't know. I has to wait for van. Then fell asleep, about to lose reception. From Greg, when are you getting back?
Be an adult, woman.
Weird, Chuck's not answering his phone either.
You have kids and
Miss
a job.
Jackson,
Make it
that's
work.
because we had an autopsy this AM, so did I.
Thousands.
He should answer when he's done. I'm not sure I still have it figured out, Ohio.
Hundreds of thousands, probably. I don't know. I don't have the statistics on this, but
From Greg,
you're not alone.
when are you going to be home today? ETA. I need you to take the kids soon as you get home because I've got to look for a new job. Hello? I have bad service here. This is from Miss Jackson.
So
I don't
she
know.
doesn't have-
I have to make it to Ohio before Friday somehow. I'll also have
She doesn't have childcare, so she killed the only childcare she had. Good job.
to wait for van to be fixed. Chuck's driver coming to get Bodie. Your body. Sorry. From Greg, well, I hope you're home by today. Otherwise. According to Chuck, not till tomorrow now. I open cans of worms because I have nothing to lose now. Sorry, but I guess I'm just not cooperating. I should be happy I lost my job. From Miss Jackson, I told you first text, car being fixed tomorrow, and I still have to get to Ohio. I told you first text,
Why do you have to get to Ohio if you lost your
Again.
job?
I told you first text, car being fixed tomorrow, and I still have to get to Ohio. From Greg, what court date do you have tomorrow?
Oh, Ohio's a court date?
Meeting at, Ms. Jackson replied back, meeting a judge, no hearing set yet. October 5th is court, why?
For what?
Greg asked, trying to figure out what is going on. I don't see any court dates from the last time you said you were there. Sorry, I don't trust a word you say. Everything is always riddled with half-truths and half-lies. So I'm going to start letting people know the truth.
Got her number.
From Ms. Jackson, first of all, it's under a trust, we meet a lawyer, which mine quit. Papers are at home, asshole. I can show you when I get back. So fuck off. It won't come up by searching my name. From Greg, well, the scheduled court for October does, but not just talking about court. Supposed to meet her tomorrow. From Greg, sorry, wrong person. From Ms. Jackson, I'm not, and I didn't make it to Ohio. We are coming back, but won't be back till later. From Greg, Kay, be safe. Are you going to be home tonight so I can drop them off in the morning? From Ms. Jackson, I am taking my time coming back home. Won't be back till tomorrow evening, stopping by a FH and staying in Charlotte tonight. Awesome, you really did cost me my job, thanks. You told me you'd be home later, so I told my boss I'd work tomorrow. Thank you, trying to salvage my F*** life, unreal. All I can say is wait for the storm. From Miss Jackson, I never said when, I said later. From Greg. God be with you in your travels. Enjoy yourself. From Ms. Jackson. Actually, I specifically said I am not coming back today, but we didn't make it to Ohio. If you read the first text I sent. From Greg. Tell it to God. Huh?
And what is the date? Thank you. What is the date of that text conversation?
Scroll down a bit. Beginning on 9/22/2020. Until 9/25/2020 at 6:43 p.m.
Okay, and now we can go to admitted exhibit 98. I'm not going to give you that much.
Hope so.
Flight out of Myrtle Beach.
September 24th, 7:01 a.m.
So during the time period of the conversation you just read?
Yes, ma'am.
Your Honor, I have no further questions. If you just answer Ms. Burton's questions.
Cross-examination. Mr. Your Honor, did I have a couple minutes based on, the information you just provided to you?
For the record, this was provided 3 or 4 years ago.
But she lied, right? She didn't lose her job.
Your Honor, could we let our potential witnesses go further back? Yeah.
So were you asked to look at Chris Dontell's phone?
I was asked to look at several devices, but I can't remember if I did. I don't believe I did Mr. Dontell's phone.
So if we sit here today, there's information that you should or could not cross-validate related to where Meagan Jackson was, location data-wise, and Chris Dontell. You don't have that information.
I'm sorry, I didn't.
Well,
Here's what I'm asking, sir. When, on 9/30, September, on 9/30, when Meagan Jackson goes to UPS and FedEx, Chris Dontell is with her. Are you aware of that?
I testified to the data on the device. So that's what the device is analyzed.
Okay. So you're not aware that the two of them were going there to try to put a stop to anything coming from that?
I'm the digital. I do digital evidence, sir. I'm not the investigator in the case, so.
On those dates you were showing us and times you were showing us, everything I got from y'all had 2 different kind of time periods. Sometimes it would be accurate, sometimes it would say UTC. On the ones that were shown here today, were those the time spent on the document, or were those not yet converted to UTC?
Which ones? What did
Okay.
you show me? Which ones were
Yeah,
UTC?
I'll give you an example. Find one.
What exhibit are you showing?
I'm gonna show them 153 and 156. 147. Which is UTC then?
Where?
Right
Right here?
Yes, sir.
Yeah, that's UTC -5, New York. That's local time zone.
Okay, it's -5. So on some of mine, it said -5. I had to do the math myself, and on some, it was already done for me. So
Which ones did you have to do it for? Or did you have to do the math on it?
We're talking about thousands. We're talking about thousands and thousands of documents. I mean,
That was just an innocent
I guess what I'm asking you
question. He was being
is there any way
nice.
for-
What? Don't be.
for us to know, see here, 155. Time zone settings, UTC. See how it says that?
That's just the, yes, sir, that's just the summary. That's the name of the time zone at UTC that shows the setting right here again is UTC -5, New York, sir.
Okay, so does that mean that the UT, it has
It means-
been subtracted from it, or you have to do a subtraction from it?
No, it's in the local time.
If that's converted time, percent. One of the things I couldn't get a grasp on, isn't the time flow this way? Erica Dontell gets a message on the morning of 9/27. That's the first time she received information about the affair between Chris Dontell and Meagan Jackson. That's your understanding?
I mean, I don't know what the first time, what she knew. I know what the data that was on.
I think she's talking about the misfit toys from Rudolph.
Is that morning, wasn't it? Sir?
I would have to see.
On the morning of September 27th. The morning of September 27th, Erica Dontell received the first indication that there was an affair going on between Meagan Jackson and Chris Dontell.
Is this the email you're talking about, or are you talking?
No, sir.
I don't know, sir.
On this? All right. Because right after that, what's sent to Meagan Jackson is a message from Chris Dontell.
Objection, Your Honor. Counsel's testifying.
All right, just don't testify. Yeah, well, Your Honor, this is, I'm having to explain to him the fact, that he can, I'm gonna ask him the fact that he can deny it, or he can respond to it because he likes. I don't think it's an improper question. How do you get the question now?
Your Honor, if I may respond.
Okay, so you would then know that Chris Dontell sent her that information, that Erica had received.
That Chris Dontell sent.
Chris Dontell sent that information to Meagan Jackson and said, look what's been exposed.
If you could please show me, counsel.
You looked at Meagan Jackson's phone, right, as part of your extractions.
I did.
At 9/27, on 9/27, September 27, at 10:30 p.m., Chris Dontell sent Meagan Jackson a couple of lengthy messages, which included the information related to Erica Dontell.
Objection. Counsel's testifying.
Without the report, without an excerpt showing me exactly what you're talking about, that one phone extraction is so large, it's impossible for me to know all the data, the dates, times. I mean, with all due respect, I mean, that's a lot of information for me to recall off my head. So if you would please show me a portion of my report.
No marks for identification, Your Honor.
I don't think I've ever been there. My mom grew up in Virginia, and it is beautiful. I love it up there. Travis and I want to go up there. He wants to get a side-by-side and go off-roading up there in the mountains. But we can't afford it. He thinks we'll be able to afford it one day. I don't see how. Unless this channel takes off. That's my dream. That's what I want to do. I've not told him because I want to do it.
Defendant Exhibit 4, identification.
Side by side.
Thank you, Counsel Ford. Or may I approach the witness? Yes. I'm going to hand you what has been marked. This is Exhibit 4 for identification only. Could you look at that and identify in the green bubbles if there appeared to be information you can send to Meagan Jackson?
I mean, this is a visual representation of what it would look like at from the date in the device.
And it's a timestamp. A little time synchrone. You share that time with us?
Which one, sir? All three?
Yeah, just the first.
He can't.
Oh, yeah, yeah.
Evidence if he's going to testify, I promise.
Oh, yeah, yeah.
Give it to him.
Is this
Refresh his memory.
Let me see it again.
Yeah, yeah. Take a chance to look through it.
Okay.
Does that refresh your memory as to what information, or that information in large fashion was sent to Meagan Jackson from Chris Dontell on the evening hours of 9/27?
It does not.
Okay. Thank you. In reviewing Meagan Jackson's phone, you would have seen other messages. Because I've seen you just testified to a number of messages. Isn't that right, sir?
That's correct.
And part of that was try to help you get context. Is it my training? Is that right, sir?
Yes, sir.
Okay. And so it would have been important to you, I imagine, that on 9/27, that Meagan Jackson reached out to Chris Dontell to let him know she was trying to help him figure out.
Objection, Your Honor.
So testify. Ask your question.
Keep testifying.
Are
Make him
you aware
stop, Judge.
that Meagan Jackson contacted an IT professional to try to help her figure out, try to help Chris Dontell figure out?
I'm allowed to go ahead.
Contacted an IT professional to try to help Chris Dontell and Erica Dontell figure out where the 9/27 message had come from.
I'm not.
Are you aware that Meagan Jackson tried to help Chris Dontell and Erica Dontell figure out what platform had been used to send the message that was sent on 9/27?
Repeat that, please.
Are you aware that Meagan Jackson tried to help identify the platform that was utilized to send the anonymous 9/27 message?
No. No, sir.
He did not.
You read the messages between Meagan Jackson and Gregory Rice, is that correct?
I did.
Are you aware that Meagan Jackson eventually confronted Gregory Rice about the 9/27 message that was sent to Erica Dontell?
I don't recall right now.
Okay. Okay. So, beg your pardon, indulgence, please. You're aware that on 9/28, Meagan Jackson told Chris Dontell that she was not public.
Objection, Your Honor.
You said you read messages. You read messages between on Meagan Jackson's phone. Is that correct?
That's correct.
Did you recall sending messages from Meagan Jackson, told Chris Dontell she didn't want to do this anymore?
Objection. And move to strike, Your Honor.
Wasn't told. So as we sit here today, just want to make sure it's clear, you agree that y'all have, you've been presented with cherry-picked information from text messages between Meagan Jackson and Gregory Rice. Is that?
When we do reports and we do extractions, the UFED reader report that's for a force multiplier, so everything, as I testified earlier today, that these extractions are extremely large, so there's more eyes on it.
Okay. No further questions, John?
You're right.
Nothing from the state, Your Honor.
All right, give me a second. Ladies and gentlemen, it's been a long week. We're going to go ahead and break this.
Okay, yay. We are on day 4 now.
He's always.
Are they going to put on a defense? Because I think this is the last day of trial.
Over the exhibits with the court reporter. 99A through J, she does not have specifically admitted, but she does show that Your Honor allowed us to publish them, so I would just ask that they be formally admitted. This was where we had 99A through J and 99A2 through J2. It would have been during Lieutenant Wells' testimony on Friday.
I've got 99, got admitted into evidence over defendant's objection, 99A2 through 99J2 admitted into evidence without objection.
So it may have just been that I wasn't there. As I said, in that case, this was, I believe, the H-Gabe email. And so 99 was the portion of the report that showed the H-Gabe email. 99A through J would have been the images. Let me just double check that.
Yeah, I don't have 99A through J. I've got 99A2 through 99J2.
Right, and so again, I probably just was not clear when I spoke. I handed Lieutenant Wells both 99A through J and 99A2 through 99J2, and we went through them at the same time. So 99A was the IMGDB image from the HGAB email, and then 99A2 was showing that that image had been cached on the defendant's phone prior to the email being sent.
So you're seeking to admit now 99A
through J.
Through J.
Yes, Your Honor. And I believe we did go through them at the bench.
Mm-hmm.
And all of this is part of State's Exhibit
99.
99.
Yes, so in 99, Your Honor, you can see smaller versions of the images. So then Lieutenant Wells testified that he went to that image and then was able to show that image on the defendant's phone.
All right, what's the defense position?
Your Honor, we objected to them as they were coming in. What the record shows, Your Honor, the record shows they're not in. They're not in.
All right, I'm going to admit State's Exhibits 99A through 99J. Since State's Exhibits 99 is already admitted into evidence, and leave this portion of that.
Yes.
Good. Okay.
And then there's some question as to 60 of the surveillance from Lowe's video. Detective Drew Edwards, I think he would have been Wednesday.
He was.
I believe he was Wednesday.
You're talking about defendant's exhibits what?
State's Exhibits 62 and 63.
Yeah, they were never put in. What's the defense position?
It's fine, Your Honor, they're not in this. I don't believe we.
They were marked for identification, never admitted into evidence. What's the defense position?
Whatever the record shows, you know.
All right. State's Exhibits 62 and 63, they want to put in, I'm not going to put in.
That's fine, Your Honor.
All right, anything else on this study?
Nothing from the state, Your Honor.
Anything from the defense before we bring the jury in?
Nothing from the defense, Your Honor.
All right, let's bring the jury in. All right, ladies and gentlemen, welcome back. Hope everyone had a good weekend. Hope everyone had a good Father's Day. We're ready to resume with the trial of this case. Please make sure you have your own notepads and no one else's notepads. State and call your next witness.
Your Honor, at this time, the state rests.
All right, ladies and gentlemen, the state has rested their case, and now is the time of the trial where I have to take up some matters of law with the defendant, with the parties, the state and the defense. As I told you earlier, when we discuss the law, it often requires us to reference factual issues, and we don't want you to be influenced by anything that I say or the attorneys say. So I'm going to excuse you back to the jury room for just a few minutes, and we'll bring you back out.
right, any motions? Your Honor, we move for a directed verdict on the conspiracy charge. Testimony indicates from all witnesses is that there was no agreement between Jackson and Mr. Dontell. Of course, that's required for the charge. He testified very forcefully. He knew nothing about it, had nothing to do with it, hadn't agreed to anything. So, under the facts and the law, that charge should be dismissed.
All right, the state's position.
Your Honor, we would ask that you deny the defense motion. In order for a directed verdict to be granted, there must be a failure of competent evidence. And in this case, we believe that there is ample evidence that the defendant and Mr. Dontell acted together. We believe that the conspiracy continued through the disposal of Mr. Rice's body. Certainly there is evidence that they went to the preserve on the 29th or 30th, and the day that Mr. Rice was murdered, to engage in target practice. There was a text message indicating the defendant, I believe, said, "I'm all for popping a tire now." And Mr. Dontell said, "I agree." I believe that's a question for the jury.
So you're saying Mr. Dontell lied on the stand when he said he didn't know anything about it, she jumped out and started shooting?
No, Your Honor. I believe that the way his testimony came across was that he thought she was kidding, and he actually testified at one point. She said, "I hate my kids, I hate my mother, I hate this person, I hate that person." But the conspiracy certainly lasts through putting Mr. Rice's body in the back of the van, storing him at the Myrtle Beach funeral home, and disposing of his body.
No, conspiracy is a pre-arranged plan prior to the act. Disposing of the body is the accessory after the fact. Conspiracy, you have to have a pre-arranged plan between two or more people to commit the crime, and that they actually carry out that crime pursuant to the pre-arranged plan. What evidence do you have that there is a pre-arranged plan between this defendant and anybody else to commit the murder?
Your Honor, I would just point to the evidence that I've already highlighted, but I will leave it in the court's discretion, certainly.
All right, I'm going to grant the motion as to the conspiracy charge. I don't see where the state has presented any evidence of a pre-arranged plan between this defendant and any other person to commit the crime.
Your Honor, on the remaining charge of murder, as I understand it, that would be the only charge
That's right.
remains.
That's correct.
We would like to have that dismissed also, based on this theory, that the reliability of Mr. Dontell is so flawed. Even as prosecutors brought out, he lied many times. He returned, he said he was afraid, he admitted returning to his relationship with Ms. Jackson. So our position is no reasonable jury could find there was murder here, because they would have to believe Dontell. And his testimony is so flawed that that wouldn't be a just verdict.
All right, I'm going to deny the motion. I think the fact that he has testified at least creates a jury question as to whether or not he's believable or not. So I'm going to deny that motion. All right, any other motions?
That's all from the defense, Your Honor.
All right, we want to go ahead and let me question your client on her right to testify.
Yes, sir, Your Honor.
And if I can get you to stand and raise your right hand, please. Do you swear or affirm to tell the truth, the whole truth, and nothing but the truth?
I do.
Your name is Meagan Marie Jackson?
Yes.
All right, Ms. Jackson, at this time, I'm going to explain to you certain rights that you have. If you do not understand anything I say, please let me know. And if you want me to explain anything in more detail, please let me know. You understand that?
Yes.
All right. We've now reached the stage of the trial where you may present your defense. You have the right to claim the protections given to you by the Fifth Amendment to the Constitution of the United States. This amendment states in part that no person shall be compelled in any criminal case to be a witness against himself. This means that you cannot be required to testify in this case. You have the right to testify on your behalf. However, no one can make you testify. This is a personal right, and no one can waive this right except for you. If you decide to testify, you will be subject to the same rules that govern other witnesses, and you may be questioned and examined and cross-examined on any relevant issue in this case. In addition, if you have any convictions involving dishonesty or false statement or for crimes punishable by imprisonment for more than 1 year, and this court determines that the probative value of admitting this evidence outweighs its prejudicial effect to you, the solicitor will be able to introduce your record to attack your credibility. Now, are there any prior?
No, Your Honor.
All right. If you decide to testify, this decision on your part must be freely, voluntarily, and intelligently made with the knowledge of the protections given to you by the Fifth Amendment to the United States Constitution and the consequences of your decision to testify. If you decide not to testify, I will instruct the jurors that they cannot give the fact that you did not testify any consideration whatsoever, and that there is to be absolutely no prejudice to you because you did not testify. It's left entirely up to you whether or not you testify. You may talk with your attorney, your friends and family, or anyone else, but the final decision will be left entirely up to you. Now, do you understand what I've explained to you?
I do.
Do you have any questions about what I've explained to you?
No, sir.
Have you discussed with your attorneys whether or not you should testify in this case?
Yes, sir.
All right, do you feel like you need to talk to your attorneys anymore about this issue?
No, Your Honor.
All right, is there anybody you feel like you should talk to about this issue before making a decision?
No, sir.
Have you made a decision as to whether or not you wish to testify in this case?
Yes, sir.
And do you wish to testify in this case?
No, Your Honor.
All right, and is this your decision?
Yes, sir.
All right. Anything further the defense wants on the record regarding the defendant's right to testify?
No, sir, Your Honor. We talked to our client thoroughly about her right to testify, as have you, and this is her decision, and we stand by her.
Anything further the state wants on the record regarding the defendant's right to testify?
No, Your Honor.
All right. Will the defense be closing arguments, charges, and deliberations?
Yes, Your Honor.
All right. Let's take about, I've got some of the charges done. It's probably going to take about another 30 minutes. I'll finish up the charges and get you a copy. You can take a look at it. You can do one of two things. If you want to submit something, you can submit something. If you want to wait and get my proposed charges, review them, and see if you have any objections or additions, then you can do that as well. Okay?
Your Honor,
Yes, sir.
quick question. There was discussion about charging the jury before and then closing, or closing and then charging.
Right.
We would prefer you charge before. I didn't know if the state had any preference, or if you had any preference, Your Honor.
Well, I generally charge after unless both sides agree.
So that's fine, Your Honor, and whatever the state would like, that's
We
fine.
prefer after, Your Honor.
Okay, I'll charge after.
That's fine.
So, in the closing argument, since the defense has not put up anything, the state will close in full.
Yes.
And then the defense will close in full.
Yeah.
That'll be all closing arguments.
Thank you, Your Honor.
All right, let's take about a 3-minute break. We'll come back. Okay, yes, sir.
Let me ask this. We're concerned about one charge you're going to be asked to give, which is hand of one is hand of all. We'd like to be able to address that before we make our argument.
All right. All right. Well, let's go over that now. Is there a hand of one? I mean, you're saying she committed the act. So what evidence is there that Mr. Dontell committed the act and she was there aiding and assisting in the commission of that?
Well, Your Honor, without being able to read the defense's mind, I'm sure they are going to say that Dontell is the one who killed Mr. Rice.
I'm sure.
Therefore, the presence of both the defendant and Mr. Dontell throughout the night, including going to the preserve, it's up to the jury to decide whether or not they were acting together for hand of one, hand of all, but I certainly think there's enough evidence in the record with them being together the entire night. Dontell actually driving Ms. Jackson's van to the location, helping to load Mr. Rice's body into the back of the van, again, all the way through disposing of the body. It's up to the jury to decide whether or not Mr. Dontell knew what was going to happen or not. I believe that that's a question of fact to the jury.
But the question is, for this defendant to be guilty under the theory of the hand of one is the hand of all, you have to have Mr. Dontell committing the crime and her there aiding and assisting in the commission of the crime. If you have her committing the crime, it's not the hand of one, unless it would be Mr. Dontell guilty of that hand of one is the hand of all is that you are there aiding and assisting someone else in the commission of the crime.
But again, Your Honor, for trying to forecast the defense argument, it is likely, I would think, that they argue that Mr. Dontell pulled the trigger. It is therefore up to the jury to decide either way. They can believe all of his testimony, none of his testimony, or part of his testimony. So it would certainly be within the jury's purview to say, well, we believe most of what he said, but we think he pulled the trigger and not her.
But what I'm saying is, what evidence has the state presented that he did pull the trigger and she was there aiding and assisting him? That's the hand of one is the hand of all. What has the state presented in its case in chief that shows Mr. Dontell committed this crime and that she is guilty as a principal because she was there aiding and assisting him in the completion of the crime?
I think that given the fact that the jury can believe all, some, or nothing from Mr. Dontell's testimony opens that possibility that he is the one, again, as I'm sure the defense is going to argue, that he is the one who fired the gun and not Ms. Jackson.
What evidence do you have that he is the one that fired the gun?
We don't believe that he is the one, but certainly there is that possibility within his testimony. The jury believes only part of what he said.
Your Honor.
Your Honor, I'd like an opportunity then to consider.
The evidence that goes to the jury that Mr. Dontell is the one that committed the murder and that Ms. Jackson was there aiding, assisting in the completion or commission of that crime, then you've got the hand of one, it's the hand of all. But as I look back, I'll look back over my notes, I don't know that I recall the state putting up anything that shows Mr. Dontell is the one who committed the crime. Now, they can argue that, but I don't know that there's anything in the record from the state that shows Mr. Dontell as the trigger person, so to speak. I'll look back over my notes, you do your research, and we'll come back and readdress it.
Thank you, Your Honor.
All right, thank you. Let's take about a 30-minute break. Before I start reviewing notes and going over all Mr. Dontell's testimony where he was charged with mistake and pled to accessory after the fact. So I think there is evidence there that he committed the crime and then she was acting. That's the reason I want to be on the record, the reason for my decision. All right, anything from the state before we bring the jury in?
Your Honor, if I can just have a moment. I was waiting for the final ruling to make sure I didn't need to make any adjustments to my PowerPoint, so I just need Ms. Dean to set it up.
That'd be fine. That'd be fine. Okay, she can go ahead and do this. I'll do however y'all want to do, since it's just one indictment and it's going to be either guilty or not guilty. Typically on that, I just send the indictment, let them write the verdict on the indictment rather than there's no lesser included offenses or anything where I need to do a verdict form. Is that all right to say?
It's fine with the state, Your Honor.
That's fine, Your Honor.
Okay. I guess when we bring the jury in, the state is rested, I'll ask the defense, is there anything you can say the defense rests?
Yes, sir, Your Honor. Yes, sir, Your
I'll
Honor.
let you rest on the record in front of you.
Yes, sir, Your Honor. Thank you.
The defense doesn't have to do anything. Absolutely nothing. They don't have the Burden of proof.
I'm sorry, if the defense is going to renew their motions after they rest, would it make sense to argue them now rather than having the jury come in and out?
I didn't, and I never really understood that. I don't know if they can make motions after they rest when they don't present
Right.
anything, because there's nothing new
Different.
presented, and I think their motions and objections are already served.
Okay, I wanted to avoid them coming in and out.
All right, anything from the defense before we bring the jury?
I believe, Your Honor, that would do it if we're going to be done with arguments. We just have our objection to the warning involved, which is noted. Besides that, Your Honor, I think we'll be ready to proceed.
All right, let's go ahead and bring the jury in.
Closing arguments. Yay! Super fast trial. Zoom trial.
All right, ladies and gentlemen, welcome back.
Your Honor, the defense rests.
All right. Ladies and gentlemen, the defense has rested their case, so all the evidence has been presented to you, and now is the time of the trial where the attorneys will make their closing arguments to you. And just like their opening statements, these closing arguments are not evidence. It is simply the attorney's contention as to what they think the evidence has shown and the law to be applied in this case. If at any time an attorney references a factual issue that is different from the facts as you find them to be, or references the law that is different from the law as I will charge you at the close of their arguments, then you're to disregard that portion of their arguments, because this is not evidence and it's not a charge on the law. It is just the attorney's contention as to what they think the evidence has shown and the law to be applied. All right, state wish to close?
May I please report?
Yes, ma'am.
This is the tale as old as time, as you were told in the opening. It involved an affair, a pregnancy, and a murder. But there was a fourth aspect of this case that is equally as important, and that's deception. The defendant was the center of the affair, certainly the pregnancy, and most definitely the murder. But the evidence has also shown that she was the center of the deception. In fact, she is a master of deception. I guess the correct term would be mistress of deception, but master of deception is a little bit more common. As you learned during the trial, the defendant and the victim had 4 children together. You actually heard from their oldest child. And think of the strength that took Savannah to come in and testify against her mother in the murder of her father. They had 4 children, but they had been separated for about 10 months to a year before Gregory Rice was murdered. They still had that connection of children, as you always do when you share children with someone else. And if you do the exhibits, because you'll get to bring them back into the jury room with you, you will see that their conversations were mainly about the children, about Greg wanting to pick up the children. When can he see them? So that was the tie that bound them together. The defendant, meanwhile, she comes into contact with Christopher Dontell during the course of her work, and she sets her sights on him for some reason. She begins to show up at his favorite restaurant. She ingratiates herself to him, and they begin an affair. She infiltrates the Dontells' marriage and life. She moves to their community. Erica Dontell testified that they spent almost all the time together, her family and his family. And then she began to spin her web of lies because she wanted to destroy the Dontells' marriage. But she also wanted to get rid of Greg. And so she started to frame him for revealing information about the affair. You may recall that during the trip to Florida, that was the defendant, Mr. Dontell, Savannah, and one of Savannah's friends, the defendant showed Dontell one text message. All I can say is wait for the storm. And based on this text message, she told Dontell that she was terrified of the victim. Didn't want to be near him. He was hell-bent on hurting her. You have to come with me. I'm going to confront him, but you need to be there because he is going to hurt me. Remember, all I can say is wait for the storm. But, and I know it took a little bit for Lieutenant Wells to read through that whole conversation, but especially here, the context of that one text is extremely important. Because you should recall, and again, you will have the exhibit in your room with you, that the conversation was about the children. Greg did not know that the defendant and Dontell were in Florida. He thought they were in Ohio. He was caring for the other 3 children, and the defendant had stayed away longer than she had told him she would. And his job was suffering as a result. He couldn't work because he had to care for the children. And so that's what, he continually caught her in lies. You told me you were going to be home yesterday. You told me you had a court date. I'm tired of all these lies. So the storm was to expose the lies. I don't trust a word you say. Everything is always riddled with half-truths and lies, so I'm going to start letting people know the truth. Not, I'm going to kill you, I'm going to hurt you. It's, you lie to me, and your lying to me affects my life. And people need to know that they can't trust what you are going to say. Again, if you look at the entire conversation, you will see that Greg is saying, thanks, just text me when they're ready, please. Hope your day is going well. Boy, that sounds like someone who is out to hurt someone, right? When can I pick up the kids? I hope your day is going well. Greg was not threatening the defendant. Greg's only concern was seeing and caring for his children. The defendant, on the other hand, so go ahead and run your fucking mouth again. Thanks for being an ass about it. Who in that text conversation was more aggressive? It was the defendant, not Greg Rice. Greg Rice had no intention of hurting Meagan Jackson. So the defendant pinned it on Greg Rice. So she begins with these text for free messages. One of them included the list of the 4 people who had gone to Florida. That couldn't have come from Greg because he had no idea where she was. He thought she was in Ohio. He certainly didn't know that she was with Christopher Dontell because otherwise that would have come out in the text. So this text came from Meagan Jackson. How else do we know that the defendant is the one who sent these text for free messages? If you look at, there was one IMDb link that you can make out. This is what pulls up. At the top of that is Christopher Dontell's number, meaning that this is a photo, not even just a capture. This is a photo, someone taking a photo of the defendant's phone and sending that, uploading it to IMDb, and sending it to Erica. Lieutenant Wells showed you that text conversation in the defendant's phone. How would Greg get the defendant's phone in order to take a photo of this text conversation and send it? How would he even know about this text message? And if you read the content of this text message, believe me, it was specifically chosen to hurt Erica the most.
I did too, y'all. Why did we done by now?
Then, when that didn't work, the defendant started this, she sort of upped the ante a little bit. She started talking about a package is going to be coming in the mail. And already she's, again, blaming Greg. And let me actually backtrack for 1 minute with the text for free messages. Don't forget that when Erica said to her husband, call her now, and they called the defendant, who did the defendant say was sending those messages? It's got to be Greg. There's no evidence in the record that Greg cared a whit about who the defendant was sleeping with. All he cared about was his kids. But when the text for free text did not work, she begins this campaign about a package coming in the mail. And again, she's blaming Greg. So this is really a win-win situation for her. She's telling Dontell to intercept the package. Okay, well, if he doesn't intercept the package, then number one, it hurts Erica, perhaps drives a bigger wedge in their marriage, but Dontell is going to think that Greg is trying to destroy their marriage. But if Dontell does intercept it, again, there's still that notion in the background, look what Greg is doing. Look what Greg is trying to do to your marriage. So she had started this little campaign about the package on September 28th. And then on September 30th, we see, and I tried to put the exhibit numbers here so you'd be able to reference them if you wanted to. We see on her web searches that she searched for the location of both a UPS store and a FedEx store, or that she was actually at those two locations. Further indicating that she is the one who sent the package. Even more telling is the fact that she deleted her search for the location of where the FedEx store. How many people here have ever gone to the trouble of deleting a search for a location as blank, able to intercept the package? And you may recall that he said, I opened it up, I didn't look a lot at it, I just brought it over to the defendant, but it was photo collages and pictures of text messages. So then we move on to the notepad, the links in the defendant's notepad. Now remember that she started these text messages about the package coming on the 28th. Well, on the 27th, she starts uploading all of these images into IMDb, setting the stage. And again, notably, October 2nd, she sends that to the trash. But Lieutenant Wells was able to access each one of those IMDb links, which he was also able to show you were cached in the defendant's phone. Now, these are just some of them. I think it was exhibits 100A through S, right? But if you look at these, text conversations with Dontell's number at the top, photo collages, exactly what Dontell saw in the package. And then also, while this is going on, while the defendant is feeding Dontell this pack of lies about Greg is trying to expose the affair, I'm so scared of Greg, we have evidence of, further malice towards the victim, where there was a text message about popping a tire. I'm all for popping a tire now. So the package still doesn't work. Dontell is still married. He's still married to this day. Whether you agree with her decision or not, Erica Dontell did not leave her husband when word of the affair came out. Did not leave her husband when word of the pregnancy came out. Did not leave her husband when he was arrested for murdering his lover's baby daddy. Still has not left him. So the defendant's campaign to destroy that marriage didn't work, but she kept trying. So then we get to the H-Gate email. And if you recall, this H-Gate email, which was sent on October 1st, but there was evidence that the defendant's phone had accessed that account on September 27th with a password that was stored in the keychain of her phone. So she's accessing that email account a full 4 days before this email is sent. And the email is sent, so let's widen the web a little bit here. It's not working that I just send things to Erica Dontell. Now the defendant's including Erica Dontell's sister and father. Maybe this will work. Maybe this will break up the marriage. Again, trying to blame it on Greg, but how is Greg going to get these images? These are all clearly from the defendant's phone. And Lieutenant Wells told you that he found them in the defendant's phone. So while she is saying at every chance she can get, expose the affair, this is all Greg's fault, it is clearly her fault. And when this still doesn't get the desired result, the next step of the plan goes forward. So this email was sent on October 1st. Now we go to October 2nd. And they go to the preserve where they had been on the 29th, the 30th, and now the day of the murder. And they engage in target practice. So on October 2nd, they were together all night. Christopher Dontell told you that, but the evidence tells you that also. As you think through Christopher Dontell's testimony, think of how it's corroborated by phone records, surveillance videos, LPR photos, starting when they left their community, the community that the defendant moved into, knowing that the Dontells already lived there. So they're leaving their community within moments of each other. And the phone activity shows the same thing. They go to the preserve, again for target practice. We see both cars leaving. We saw them coming in as well, but there they are there are the phone records showing that both phones are hitting off the tower that serves the preserve. Seated at the bar together, again, the phone records show that they were together all night. All the way through to 11:06, 11:07 p.m., the last connection that Greg's phone makes to any tower. We ran the surveillance video for you from Just Ask Hal, or the Lowe's food parking lot. You see the defendant's van and Dontell's Ford Explorer. You see them, you never see Greg. Why? Because he was being stored in the Myrtle Beach Funeral Home cooler. We know that the defendant was the last person to talk to Greg Rice. Twice. First she calls at 9:45, and then again at 9:58. And at that point, Greg Rice starts walking towards the Clay Pond Road entrance to the Arrowhead community. They leave Arrowhead at the same time. Again, supported by the phone records. And we know what happened during that 6 or 7 minutes in the Arrowhead community. Christopher Dontell testified he was driving the defendant's van. As they're pulling down Arrowhead Boulevard, they see the victim walking down the road. Dontell begins to pull over, and the defendant says, "No, turn around, make a U-turn and pull up in front. Don't be awkward." And then as soon as he pulls up, the defendant jumps out of the car and fires multiple shots, killing Greg Rice. And what's interesting is every single shot is on the left side of the body. So picture this, that the van is in front of me. I'm Greg Rice, I'm walking up, door opens, I see the defendant pop out with a gun in her hand, and I start turning to run for my life. Shot, 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 shot. He saw it coming. Now, the defense made quite a bit of, well, everyone, like Captain Wilson, did you park in the lot? Did you go to the sidewalk? Did you walk up to the apartment? Did anyone say shots fired? Did you see any crime scene? Focusing first on whether or not there were any calls about shots being fired, I suggest that anyone who has lived in Horry County for any length of time has heard gunshots. And quite frankly, if you call the police every time you heard gunshots, you wouldn't have time for much else. But what you should also consider is where the shots happened. In this, next to this 8-acre tract. And there was testimony, I believe it was by Sergeant Jones, that a shot from a .22 caliber, which is what the murder weapon was, is much softer than, say, a 9mm or a .357 Magnum. But the fact that no one called in shots fired is really of no moment. Again, we go back to the last data connection that we have with Greg Rice's phone. And as you were watching that sort of animated slide, Dr. Marcus loves these animated slides, puts them in every presentation. But if you looked at that animated slide detailing the last sort of life of Greg Rice's phone, you will notice that Greg's phone is tracking with the defendant. At one point in that animation, it was geolocation data of the defendant with Greg Rice's phone. Christopher Dontell also told you that after they had stored the body in the funeral home, at some point in the evening, the defendant wanted to go back and get some of Greg's belongings so that she could plant them at the apartment and kind of give life to this missing person story. Well, how do we know that that is accurate? Because he told you about a trade embalmer. I learned a lot about the business of death in this case. I never knew that there was a trade embalmer, someone that would show up at a funeral home at midnight to embalm a body, but sure enough, they did. And again, geolocation data shows that the embalmer's wife, Joanne Cusack, was at the Myrtle Beach funeral home at the same time as Meagan Jackson, her geolocation data. And that's at 12:38 at night. So based on everything that we had seen so far, all the evidence that has been entered, the defendant was charged with murder. Now, typically, the prosecution and the defense fight over just about everything. But I cannot imagine a reasonable argument that Greg Rice was not murdered. Shot a minimum of 5 times and dumped in a river to be found 5 weeks later. So then what it is up to you to decide is the defendant guilty of the murder? Certainly by Mr. Dontell's testimony, she is. If you have any hesitation about that, then South Carolina has hand of one, hand of all. If they were acting together, and you heard that he had originally been charged with murder and criminal conspiracy and accessory after the fact, entered a plea with no agreements with the state to criminal conspiracy and accessory after the fact. So if you think, well, maybe Dontell did it and not the defendant, you go back to this hand of one, hand of all, which says that it doesn't matter. Two people can be guilty of killing another when only one of them has a gun and only one of them fires a shot. But I would suggest to you that there should be no question in your mind who fired the multiple shots that killed Greg Rice. Because all you need to do is look at who benefited from his murder. Christopher Dontell and Erica Dontell never met Greg Rice. Never. The news of the affair and the pregnancy was already out. So what benefit would it be to kill Greg Rice? You can't stuff that secret back in the bag. And as I said before, the news of the affair and the pregnancy did not end Dontell's marriage. The defendant is the only one who benefited from Greg's murder, and I think that's evident in the seeds that she planted along the way. In a moment, after defense closing and the judge's charge, you will be asked to render a verdict. Verdict in Latin means to speak the truth, something I would suggest the defendant has an extremely difficult time doing. But it is your job to end the defendant's continued deception and speak the truth and convict her of murder. Thank you.
Isn't it nice to watch one that's just so black and white?
Your Honor.
She's just going to take this down on herself.
Good morning. What you're going to hear in the jury charge, in terms of reasonable doubt, you're going to hear reason to hesitate. What you're looking for in this case is a reason to hesitate. And in this case,
At least now he's allowed
there
to
are
talk to
many
the jury.
reasons to hesitate. How about the first one? Every word that was just uttered to you would have been used in a trial to try to convict Chris Dontell of murder. Every single fact you have heard just 7 months ago, and it should scare you, would be used to convict Chris Dontell of murder, not Meagan Jackson. And that should horrify you.
Why?
So let's look at what you're going to hear. You're going to hear, of course, going to tell you about not holding it against the defendant for not testifying, and take that to heart. It's part of your constitutional right. And think about this for a second. When it comes to who didn't testify, you can't consider Meagan Jackson didn't testify, but you should consider the fact that they never put up the chief investigating officer. He never took a stand. You want to know why? He didn't want to co-sign this. He's ashamed of what this case looks like. Because he knows what I know, which is for you to convict Meagan Jackson, you have to believe Chris Dontell. And that's something nobody should have to do. Let's look at what they actually presented to you. Because once you remove Chris Dontell, what you start to see is there's not a whole lot of evidence of a crime, of an actual crime. They've shown to you Meagan Jackson wanted Chris Dontell to have the courage to go tell his wife about their affair. She wanted him to go tell her. That's not a crime. Now, did she do that in ways that maybe we wouldn't agree with? Sure. But her wanting that marriage, that affair to be outed, that is not a crime. And the fact that they're trying to get you over there and make that the case should tell you they had a lot of weakness in their actual case. An actual case requires them to prove things that happened at the time of the crime, which they can't do. Because for 4 years, they've been telling themselves, and anyone who will listen, that this happened at the Myrtle Beach funeral home. It wasn't until 7 months ago that they started telling you it's Flint Lake Apartments. How can you believe and not hesitate when they have shifted the crime scene 4 years later? So what did they present? Well, they presented some evidence about where phones were. You got some phone information. Okay. The problem with phone information is this. It doesn't put you in the actual what's going on moment. It doesn't tell you if Meagan Jackson drove Greg Rice alive back to the Myrtle Beach funeral home and dropped him off so that he could talk to Chris Dontell. It doesn't tell you she went inside. It doesn't tell you what's actually happening in the moment. And they knew that coming into this case. Do you think it's a coincidence that he wrote a statement out, Chris Dontell did, and hand-delivered it to Ken Marcus, and an hour later, the state has it changed? He hand-wrote a statement and told to say he did not see it happen. He was not present. He was not there. That is what he told the state. And an hour later, that's changed. Now all of a sudden, he's an eyewitness to it. If that doesn't give you reason to hesitate, I don't know what else could. I cannot think of something more important than the fact that that man would change his statement within 1 hour to assist the state to try to convict Meagan Jackson. Tell you what that does. It tells you exactly what he's about. He's about Chris Dontell. He's about himself. That's the reason he wouldn't tell Erica. That's the reason he's pushing Meagan. And that's the reason he killed Gregory Rice, because he is about himself. What else did they present? Well, look at some of the other investigators. I have never seen the investigators that took this stand. They looked sad up here. They were ashamed of this. And you should be. I mean, you spent 4 years telling everybody this happened at the Murphy Funeral Home. And the one thing that changes your mind on that is the testimony of Chris Dontell. That's the only piece of evidence that changed what they believe happened that night. Can you count on Chris Dontell? They shuffled up 2 dentists. I don't know why. They shuffled up 2 ballistics people. I don't know why. I'll tell you, I do know why. Because if you don't have real evidence of what happened in terms of the crime, what you do is you expand this trial. You go put a bunch of evidence in it, so when you go back there, you go, man, look at all this. But ask yourself as you're looking at it, does any of it actually prove what happened? You can piece it all together, but when you get right down to it, you're always going to have to come back to trusting Chris Dontell. And that's the one thing the state didn't want you to have to do, but they can never get around that. Let's talk about some of the things they clearly missed. They want you to believe that she returned a wallet and keys the following day. You might have heard that. The wallet and keys are sitting right there in evidence. Guess what you don't have to go with this? A DNA sample. You talk about easy. You talk about simple. Send the keys off. Have the DNA checked. Comes back Meagan Jackson, you might have a little something. They didn't do that. Oh, make sure you look at that blanket or that sheet. They want to tell you that sheet is evidence that Meagan Jackson had that in her van. Remember what they told you about that? They told you it looked like it came from the Myrtle Beach funeral home. Guess what that evidence was going to look like 4 years ago? 7 months ago. 7 months ago, that evidence was going to be that sheet. That sheet is evidence that Chris Dontell was sitting there in the Myrtle Beach funeral home when Meagan Jackson brought Greg Rice there and he killed him. That isn't a grind staff. She worked for grind staff transport. That was a Myrtle Beach funeral home sheet, is what they told you. It's sitting right there with Chris Dontell. So the reason they didn't like that is because they can never prove to you, and still haven't to this day, what was going on in her mind. But I think we kind of know. She showed up on October 2nd with what? When they went to the shooting range, what did she have in her car? Blow-up bag. She's still trying to woo Chris Dontell. She got blow-up bag. She's not worried about shooting targets. She's looking to have more sex, and that's what their relationship was about. You can pick any night from the time they started dating, and they are together, they are swapping cars, they're having sex in their car. That's what their relationship was about. And she was true to that on the night of October 2nd. That's what she showed up to do. Do I think she wanted Greg Rice to help her out this affair? I absolutely think she did. Was Greg Rice an imposing guy? Yes, he was. If Greg Rice had a chance to talk to Chris Dontell and tell him, hey man, get your stuff straight, I think he'd have done it. Go tell your wife, I think he'd have done it. And that's what Meagan Jackson wanted him to do. She wanted Greg Rice to help her get Chris Dontell to man up to what was going on.
This is all arguing facts, not evidence.
I'll let her go. Thank you, Your Honor. That's exactly what was going on. That's what they had proven to you, is that she wanted this affair to be outed. That's what they had proven to you. And did she go about it the right way? Maybe not, but she wanted it to be outed. What is also true, when we start talking about motive, her and Greg Rice's relationship, yeah, it's typical ex stuff. They talk a little bold to each other, you know, they fight over kids. It's typical marital, ex-marital. There's some nastiness in there. But Greg Rice, having him in her life was a benefit to her. They made a big deal telling you she's not the best mother. Well, guess what a mother who's struggling needs? Help. Getting rid of Greg Rice gets rid of her help. There is no motive there. But think about Chris Dontell on the other hand. Chris Dontell is getting word that he's about to lose Erica, could be losing Meagan, and that Greg Rice is complicating his life and is going to out his affair. There's a text. If he sees Erica, he's going to tell her. So the only person that actually has a motive, a true motive, to get rid of Greg Rice is Chris Dontell. And can you trust him? Can you trust him? Well, let's consider some reasons why maybe not. Got a little list here. Reasons that you should not trust Chris Dontell. He doesn't even recall his plea. He doesn't even recall his plea. He sat up here 7 months ago, took the plea, where he slithered his way out of the murder charge, and he doesn't remember. His handwritten statement to Marcus. His handwritten statement to Marcus that he changed within 1 hour. That's the second reason. He sat here and told you he was scared of Meagan Jackson and that he's sleeping with her. After this occurs, and he tells you, she did it and I had to watch it, I had to watch it all. He's sleeping with her. Do you think that that's really, can you believe that? No, you can't believe that. How about this, man? They slipped this right by you. The only person who has Greg Rice's blood on them is Chris Dontell. That's it, guys. The case should be over. The only person with blood on their shoe is Chris Dontell. How about this? He tried to tell you that Meagan Jackson went home after this, went from Lowe's, they went home and she showered. She got all changed up. Had to get the blood off of her. Well, guess what? If you saw the surveillance video footage, when they go back to Lowe's, she's wearing the same exact thing she was wearing when she left Lowe's the first time. She hadn't changed her clothes. She was wearing the same black scrubs. Can't trust Chris Dontell. Who disposed of the body? Who disposed of the body? Chris Dontell. Does he strike you as the kind of guy who's going to do you a favor? Is that the guy you want to go to for a favor? He is the most selfish person I've ever seen. He sat up here and told you he disposed of the body as some kind of favor. You ain't mind that. You can't. You know what? He did a lot. I called him Chris Dontell, full of lies and cries. I'll tell you when he wasn't crying. He wasn't crying when he was shopping in Lowe's. Just grabbing cinder blocks and tarps, stick them in his grocery cart, and let's grab the Pepsi. He was mortified about what had happened. He looked pretty casual there to me. I don't know about you.
I'm glad it was a short trial. I couldn't have taken that man for much.
How about that very sweet wife of his who sat up here and remains committed to him after he sent these heartfelt texts about how much he loved her and was going to stay with her after he killed Chris Dontell. He's still sleeping with Meagan Jackson. Can't trust him. How about the fact he's seen sneaking around looking for a key at a Myrtle Beach funeral home? Can't trust him. How about the fact he lied to Meagan Jackson about where he found that key? Can't trust him. How about the fact that blow up Betty is not very good target practice? Not much of a marksman myself, but I'm pretty sure if you shoot an inflated object, it just explodes the one time you shoot it. That would be the worst target practice I've ever heard of. You would want something that would withstand some gunshots. Can't trust him. And if at all you find yourself in some crazy way wanting to trust this man, I don't think you would. He flat told you. He's up here testifying, trying to get his plea reduced. That's why he's here. He's here for who? He's here for himself. That's what he's here. I'll tell you something that really makes me not trust the state, frankly. Just them having people's phones. What makes me not trust? Hand of one is the hand of all. Meagan Jackson, Chris Dontell's hands, they'll tell you we're in the cookie jar together. Well, then he takes a plea. His plea makes it impossible for him to be charged with murder. The state took his hand out of the jar. Here's what's wicked, man. Here is so wicked. And they bring him back up here and let him testify in a way where they're going to ask you to consider the hand of one and the hand of all. So what are they going to do? They're going to stick it back in the jar. When it suits them, they're gonna stick it back in the jar. And as soon as we leave here, they take it right back out. That's crooked. See what else they're gonna do? They're gonna ask you to believe a man they don't believe. They're asking you to trust Chris Dontell, and they don't trust him. You know why this conspiracy charge is gone? The court decided that not enough evidence to support the conspiracy charge to no longer have.
Objection, Your Honor.
This thing,
Move to strike.
I strike that, that's a matter of law.
When it comes down to the hand of one is the hand of all, that is there, and I knew it in the opening statement, from the ringing bell, I knew it. We were in for a wild ride, because when you're trying to count on that to prove somebody guilty of murder, you know you have a weak case. You know you do, man. If you can't put Meagan Jackson on the scene, of course they don't have a scene here, you know your case is weak. I'll tell you what really worries me. It's not that they don't trust Chris Dontell. I mean, I know they don't trust Chris Dontell. You don't trust Chris Dontell. But what I find offensive about their position is they don't trust you. They don't trust you. Because if they trusted you, they would tell you that the case we put up here, the case we put up as the state, banks on Chris Dontell telling you she just jumped out and started shooting. I had no idea what was going to happen. That's what he told you. That is their case. That's evidence they put into the record. But now they want you to just bypass some of that. Big stuff. So what happened? Mr. Britton, give us some theories. Well, here's the evidence in the record. Pretty simple. You can consider reverse truth. Very common. Co-defendant will strike up here, testify against their defendant, and tell you exactly what they did, and put it on the other person. Meagan Jackson, sitting in the car with Chris Dontell, they pull up, Chris Dontell gets out and starts shooting. And she had no idea he was going to do it. And that is, you can believe that all day long. That is as likely, and when it comes to motive, much more likely than the fact that Meagan Jackson would get rid of her father, or the children, the father of her children. But that's really not what this case, in my opinion, look, when you look at Flint Lake Apartments as a crime scene, it kind of falls apart. I don't know, I mean, they had a witness who tells you gunshots are fired there all the time. I don't know, maybe you believe that, maybe you don't. I find that pretty hard to believe. I find it hard to believe that when they're out there 9 times, nobody says, okay, listen, I'm gonna tell you, we got gunshots out here all the time. I heard some, but I didn't say anything to you the first 4 times you were here because I didn't think it was all that important. Because we just, we don't ever report it. I find that extremely hard to believe. I find it hard to believe that they claim she's out there picking up evidence the next day and nobody sees that either, in broad daylight, with her kids running around. That don't make any sense to me. That don't make any sense to me. And it didn't to them either. So you should not feel bad about that. If that does not make sense to you, you should feel good with that. Because it doesn't make any sense. And that's why the state didn't believe it. And that's why the chief investigating officer didn't testify. It's because their original position on this is probably what happened. And then you can read into the evidence. She goes and she picks him up. And she gets him to the Robert funeral home alive. And their problem is they can't tell you what happened after that. They can't blame her. And since the snake has already slithered out of the room, they can't blame him. But I can promise you, as soon as once you make that decision, Flint Lake Apartments is an unlikely spot. You have your reasons to hesitate, and the rest of this case falls at Robert's funeral home, where they themselves believe it falls. David, court's indulgence for a second, Your Honor.
All right.
Just in closing, I would just say, when you get back there, what you really follow the court's instructions, but just ask yourself at the end of the day, do you trust Chris Dontell? The only way you can convict her is if you trust that man. I don't think you can. Thank you.
All right, ladies and gentlemen, all of the evidence in this case has been presented to you. The attorneys have made their closing arguments, and now is the time of the trial when I charge you with the law to be applied in this case. The indictment in this case charges the defendant with murder. The court has already dealt with the indictment charging the defendant with conspiracy to commit murder, so you need not consider that charge in your deliberations. I remind you that the fact that the defendant was arrested, charged, and indicted in this case is not evidence in this case. It cannot be considered by you as evidence of guilt in this case. Nor does the defendant's arrest, charge, or indictment create any presumption or inference of guilt. This document is simply the formal written instrument which contains the charge made against the defendant. It is the formal document by which this case is brought into this court. The defendant pleads not guilty to this indictment. That plea puts the burden on the state to prove the defendant guilty. A person charged with committing a criminal offense in South Carolina is never required to prove her innocence. I charge you that an important rule of the law is that the defendant in a criminal trial, no matter what the seriousness of the charge may be, will always be presumed to be innocent of the crime for which the indictment was issued, unless guilt has been proven by evidence satisfying you of that guilt beyond a reasonable doubt. This presumption of innocence does not end when you begin your deliberations, but it accompanies the defendant throughout the trial until you reach a verdict of guilt based on evidence satisfying you of that guilt beyond a reasonable doubt. The presumption of innocence is like a robe of righteousness placed about the shoulders of the defendant, which remains with the defendant until it has been stripped from the defendant by evidence satisfying you of the defendant's guilt beyond a reasonable doubt. The presumption of innocence is not a mere legal theory. It is not just a legal phrase. It is a substantial right to which every defendant is entitled unless you, the jury, are satisfied from the evidence of the defendant's guilt beyond a reasonable doubt. Now, what is a reasonable doubt in the law? A reasonable doubt is the kind of doubt that would cause a reasonable person to hesitate to act. Proof beyond a reasonable doubt is proof that leaves you firmly convinced of the defendant's guilt. We know very few things in this world with absolute certainty, and in criminal cases, the law does not require proof that overcomes every possible doubt. If based on your consideration of the evidence, you are firmly convinced that the defendant is guilty of the crime charged, you must find the defendant guilty. If, on the other hand, you think a real possibility exists that the defendant is not guilty, you must give the defendant the benefit of that doubt and find her not guilty. I remind you that during this trial, you and I have certain duties to perform. As the trial judge, my responsibility is to preside over the trial of this case. I also have the duty to rule on the admissibility of the evidence offered during this trial. You are to consider only the competent evidence before you. If any testimony was ordered stricken from the record in this case during this trial, you must disregard that testimony. You are to consider only the testimony which has been presented from the witness stand, any exhibits which have been made a part of the record in this case, and any stipulations of counsel. I have the additional duty to charge you the law applicable to this case. As the presiding judge, I am the sole judge of the law of this case. Your duty as jurors is to accept and apply the law as I now stated to you. If you have any ideas to what the law is or what the law ought to be, and your idea is different from what I now tell you the law is, you must disregard your idea of what the law is or ought to be because you are sworn to accept the law and apply the law exactly as I stated to you. In every case tried in this court before a jury, the jury is the sole and exclusive judge of the facts in the case. A trial judge cannot intimate, state, comment on, or make any statement to a trial jury about the facts in a case. Since you, the jury, are the sole judge of the facts in this case, you're not to infer from what I have said during the progress of this trial in ruling upon the admissibility of evidence or otherwise, or anything that I say now during the course of this instruction to you that I have any opinion about the facts in this case. The law does not allow me to have an opinion about the facts in this case. This is a matter solely for you, the jury, to determine. As jurors, your duty is to determine the effect, value, weight, and truth of the evidence presented during this trial. Two types of evidence are generally presented during a trial: direct evidence and circumstantial evidence. Direct evidence is evidence that directly proves the existence of a fact and does not require deduction. For example, direct evidence is the testimony of a person who claims to have actual knowledge of a fact, such as an eyewitness. Circumstantial evidence is proof of a chain of facts and circumstances indicating the existence of a fact. Crimes may be proven by circumstantial evidence. The law makes no distinction between the weight or value to be given to either direct or circumstantial evidence. Nor is a greater degree of certainty required for direct evidence. However, to the extent the state relies on circumstantial evidence, the circumstances must be consistent with each other, and when taken together, point conclusively to the guilt of the accused beyond a reasonable doubt. If these circumstances merely portray the defendant's behavior as suspicious, the proof has failed. You should weigh all of the evidence in this case. After weighing all the evidence, if you are convinced of the defendant's guilt beyond a reasonable doubt, you must find the defendant guilty. On the other hand, after weighing all of the evidence, if you are not convinced of the guilt of the defendant beyond a reasonable doubt, you must find the defendant not guilty. The state has the burden of proving the defendant guilty beyond a reasonable doubt. This burden rests with the state regardless of whether the state relies on direct evidence, circumstantial evidence, or some combination of the two. Necessarily, you must determine the credibility of witnesses who have testified in this case. Credibility simply means believability. Your duty as jurors is to analyze and to evaluate the evidence and determine which evidence convinces you of its truth. In determining the believability of witnesses who have testified in this case, you may believe one witness over several witnesses, or several witnesses over one witness. You may believe a part of the testimony of a witness and reject the remaining part of the testimony of that same witness. You may believe the testimony of a witness in its entirety, or reject the testimony of a witness in its entirety. You may consider whether any witness has exhibited to you any interest, bias, prejudice, or other motive in this case. You may also consider the appearance and manner of the witness while on the witness stand. Evidence has been presented that a witness has made prior statements which are not consistent with the witness's present testimony. You may use this evidence to decide whether to believe the witness. You may also use evidence of the earlier contradictory statements to determine the truth of those statements. You must decide whether to believe the earlier statements or the testimony given at trial. If a witness is shown to have knowingly testified untruthfully concerning any material matter, you may consider this in determining whether to trust the witness's testimony as to other matters. You may reject all of the testimony of that witness or give all or a part of the testimony the weight you think it deserves. Rules of evidence ordinarily do not permit witnesses to testify to opinions or conclusions. An exception to this rule exists for witnesses we call expert witnesses. A witness who by education and experience has become expert in some art, science, profession, calling may state an opinion as to the relevant and material matter in which the witness claims to be an expert. Also states in this case, and like any other evidence, give it the weight you think it deserves. If you decide that the opinion of an expert witness is not based on sufficient education and experience, or if you conclude that the reasons given in support of the opinion are not sound, or that the opinion is outweighed by other evidence, you may disregard the opinion entirely. An expert witness's testimony is to be given no greater weight than that of other witnesses simply because the witness is an expert. Further, you're not required to accept an expert's opinion even though it is not contradicted. I instruct you and emphasize that the fact that the defendant did not testify is not a factor to be considered by you in any way in your deliberation and in your consideration of the question of the guilt or the innocence of the defendant. The defendant's decision not to testify must not be considered by you in any manner whatsoever. A defendant has the constitutional right to remain silent, and the assertion of this right must not be considered by you in your deliberations. I repeat, under your oath, you are to draw no conclusion whatsoever from the fact that the defendant in this case did not testify. The fact that the defendant did not testify should not even be discussed in the jury room. The burden of proof, as I have stated to you, is on the state. The defendant is not required to prove her innocence. The burden of proof remains on the state to prove guilt beyond a reasonable doubt. In order to establish criminal liability, criminal intent is required. For example, the mental state required to be proven by the state for a particular crime might be purpose, intent, knowledge, recklessness, or criminal negligence. Criminal intent must be proven by the state beyond a reasonable doubt. Criminal intent is always a matter that must be determined by the jury from the circumstances surrounding the situation. Criminal intent cannot be proven to a mathematical certainty. Medical science cannot dissect a person's brain and determine what the person had in mind. So the law says that criminal intent may be inferred from the circumstances shown to have existed. This is how you make a determination of whether or not the element requiring intent is present. Criminal intent does not have to be established by direct and positive evidence. Intent may be established by inference in the same way as any other fact, by taking into consideration the acts of the parties and all the facts and circumstances of the case. Criminal intent is a mental state, a conscious wrongdoing. You must determine what the defendant intended to do based on the circumstances shown to have existed. Criminal intent can arise from an action or a failure to act. It may arise from negligence, recklessness, or an indifference to duty, or the consequences that is considered by law to be the equivalent of criminal intent. The defendant is charged with murder. To convict the defendant of murder, the state must prove beyond a reasonable doubt that the defendant killed another person with malice or forethought. Malice is hatred, ill will, or hostility towards another person. It is the intentional doing of a wrongful act without just cause or excuse, and with an intent to inflict an injury or under circumstances that the law will infer from evil intent. Malice or forethought does not require that malice exists for any particular time before the act is committed, but malice must exist in the mind of the defendant just before and at the time of the act is committed. Therefore, a combination of the previous evil intent and the act is required. Malice or forethought may be expressed or inferred. These terms, expressed and inferred, do not mean different kinds of malice, but merely the manner in which malice may be shown to exist, either by direct evidence or by inference from the facts and circumstances which are proven. Express malice is shown when a person speaks words which express hatred or ill will for another, or when the person prepared beforehand to do the act which was later accomplished. For example, lying in wait for a person, or any other acts of preparation going to show that the deed was within the defendant's mind would be express malice. Malice may be inferred from conduct showing a total disregard for human life. If facts are proved beyond a reasonable doubt sufficient to raise an inference of malice to your satisfaction, this inference would be simply an evidentiary fact to be considered by you, along with the other evidence in the case. You may give it the weight you decide it should receive. If a crime is committed by two or more people who are acting together in committing a crime, the act of one is the act of all. A person who joins with another to commit an unlawful act is criminally responsible for everything done by the other person, which happens as a probable or natural consequence of the acts done in carrying out the common plan and purpose. For example, two people can be guilty of bank robbery when only one of the two enters the bank and takes money from the cashier, while the other acts as a lookout in the getaway car. If two or more people are together, acting together, assisting each other in committing the offense, the act of one is the act, or is the act of all, or as it is sometimes said, the hand of one is the hand of all. Prior knowledge that a crime is going to be committed without more is not sufficient to make a person guilty of that crime. Mere knowledge that another person is going to commit a crime, even if the defendant is present when the crime is committed, is not sufficient to convict the defendant as a principal. Guilt as a principal is shown by actual or constructive presence at the scene as a result of a prior arrangement. Therefore, a finding of a prior arranged plan or scheme is necessary for a finding of guilt as a principal. The state must prove beyond a reasonable doubt by competent evidence the theory of the hand of one is the hand of all. A principal in a crime is one who either actually commits the crime or who is present, aiding, abetting, or assisting in committing the crime. When a person doesn't act in the presence of and with the assistance of another, the act is done by both. Where two or more acting with a common plan or intent are present at the commission of a crime, it does not matter who actually commits the crime. All are guilty. The hand of one is the hand of all. Present at the commission of a crime means to be sufficiently near to aid and abet and assist in the commission of the crime. However, mere presence at the scene of a crime is not sufficient to convict one as a principal on the theory of aiding and abetting. Intent is also a necessary element. But there must have been a common design or intent to commit the crime, and the crime must have been committed pursuant thereto, with the person aiding and abetting by some overt act. Intent means intending the result which actually occurs, not accidentally or involuntarily. Intent may be shown by acts and conduct of the defendant and other circumstances for which you may naturally and reasonably infer intent. The state must prove these elements beyond a reasonable doubt. Now, ladies and gentlemen, you may find one of two possible verdicts in this case. No significance is to be given to the order in which I state these verdicts to you. I simply have to state one first and one second. The possible verdicts in this case are either guilty or not guilty. Ladies and gentlemen, your verdict must be a unanimous one. Mr. Roberts, as foreperson, when the jury agrees on the verdict, you will write the verdict here under the verdict portion of the indictment. Then you'll sign your name as foreperson, date the indictment, and then knock on the door and tell the bailiff you have reached a verdict, and we'll bring you back into the courtroom at that time. Now, you have been allowed to take notes during the trial of this case if you wanted to, and I will now allow you to take your notes with you into the jury room while you deliberate on your verdict. However, note-taking is not required. Please remember that some people are better note-takers than others. Juror notes should not be given any greater weight than the recollection of other jurors. The recollections of individual jurors should be considered as reliable as notes taken by any other jurors. Now, I'm going to excuse you to the jury room in just a minute, but I'm going to tell you, don't begin your deliberations. I need to check with the attorneys to see if they have any additional charges or corrections to the charges I've given you. If they do, and I deem it appropriate, I'll bring you back into the courtroom and make whatever corrections or additional charges are needed. If there are none, the exhibits will be brought back to the jury room and the bailiff will instruct you to begin your deliberations. But do not begin your deliberations until you're instructed to do so by the bailiff. Also, we have ordered lunch for you. It hasn't got here yet, but it should be shortly. When lunch gets here, you can do one of two things. You can stop your deliberations, eat your lunch, and then resume deliberations after you eat lunch. Or if you prefer, you can deliberate while you eat lunch. The only requirement is that everybody must do the same thing. You can't have some jurors stop deliberations while other jurors continue to deliberate. But whatever you choose to do, whether you deliberate while you eat, or if you want to take a break, you can do that as well. All right, I'm going to excuse you back to the jury room, but please do not begin your deliberations until you're told to do so. Thank you very much.
We're watching this one on Verdict Watch. But it's almost over.
All right, any exceptions to the charges by the state?
No.
All right, anybody with the defense?
Just a reiteration of our objection to the hand, one hand, Your Honor.
All right, I'm going to go ahead and leave that in place to save my property.
Thank you, Your Honor.
Thank you. Anything else from the defense?
Now, can we
I'm sorry.
go somewhere where we're 5 minutes away?
Right. If you want to leave, make sure clerk of court has your, or my law clerk of court has your number for you. Okay?
Yes, sir, Your Honor.
All right. Let's make sure we have all of the exhibits.
Yes, Your Honor.
Right here. Also, if you would go ahead and bring the alternates, and that would be Mr.
Your Honor, with the court's permission, I'm going to take this to my cable and just go through and pull out the ones that were not admitted.
What one? Class. I know there's some preppy murder thing going on.
Yes, sir.
But I think if we get a verdict today, I'm going to take a break. I'm going to take tomorrow's holiday and Friday. And have a long weekend.
Ladies and gentlemen, this is the part of the trial I hate, because the law says that since we still have our 12 jurors, it does not allow the alternates to participate in the deliberation. I hate that because we make you sit through the whole trial just like regular jurors, but then we don't let you make a decision. I want to thank you for your service. That will conclude your service for this term of court, for this trial. You're at liberty to do whatever you want to do. If you want to stay and see the outcome, you can do that. If you've got lunch coming, if you want to stay and eat lunch, you can do that. If you want to leave now, you can do that. If you want to stay a while and then leave, whatever you want to do. We just cannot let you deliberate with the other jurors. Does anybody have anything in the jury room they need to get?
Yeah.
Okay. Please let the bailiff know what it is you need to get, and they'll go in and they'll get it for you. Well, no, we haven't sent the exhibits back. So just go with them, and they can go in and get whatever you want. Come back out. They'll have a place if you want to stay, you can stay. If you want to leave, you want to leave. If you want to eat, whatever. Thank you for your service. You've got a 1-year disqualification from serving jury duty. You've got a 3-year exemption. I hope you don't exercise your exemption because we do need good jurors. And I want to thank you for that. As I said, you're free to go, stay, whatever you prefer to do. All right, thank you very much.
Yeah, I don't know what's going on with my audio. Everybody keeps saying it's slow, but everything's on my settings. I don't know how this mic works. I can't tell if it's going higher or lower when I turn this little wheel. Is it going louder? What's the one in Tampa? What are they doing? It's not getting louder. Is it getting quieter? As long as it's not getting quieter. $19 hours, 43 minutes, and 30 seconds. Vinny's still outside of the courtroom. It says crowd is growing outside Dedham Courthouse. Ronnie Walker. That's not that other dude that killed his whole family, is it? Or tried to. Thought he already was in prison. Oh, no. Nope. Different Ronnie. Oh, they're just getting the exhibits ready to go back. Okay, we're going to sip all this. At least we'll get one verdict today. Hopefully two. Guilty verdicts are quick. Not guilty is usually the ones that take a while. Taking so long. Let's get this show on the road.
Ladies and gentlemen, I've been informed that the jury has reached a verdict Anything from the state before we bring the jury in?
Nothing from the state, Your Honor.
Anything from the defense?
Nothing from the defense, Your Honor.
All right, ladies and gentlemen, those of you who are with us, I give this instruction every time before the jury comes in, and that is simply to let you know that we do not have any type of outburst or anything of that nature, regardless of what the verdict is. This is just simply to let you know that if you're unable to contain your emotions, you need to excuse yourself from the courtroom now, because regardless of what the verdict is, there should be no display or no outburst or any sign of emotion whatsoever. All right, so if you need to be excused, you can go ahead and excuse yourself now. All right, let's go ahead and bring the jury in. Ladies and gentlemen, welcome back. I understand the jury's reached a verdict, is that correct? All right, and have you written the verdict on the indictment, signed it as the foreperson, and dated it?
Yes.
All right, if you would please hand it to the bailiff. All right, I'll ask the clerk if she would please publish the verdict.
Indictment number 2021 GS 2601191. The state of South Carolina, County of Horry versus Meagan Marie Jackson as to the charge of murder, we the jury by unanimous consent find this defendant guilty. Signed by foreperson Jeffrey Roberts, dated June 17, 2025. Ladies and gentlemen of the jury, if this is your verdict, please so signify by raising your right hand. Thank you.
All right, let the record reflect that all jurors raise their right hand. Any opposing to the jury by the defense?
No, sir.
All right. All right, ladies and gentlemen, I want to thank you for your service. That'll conclude your duties as jurors in this case and for this term of court. And I want to thank you for your service. I know jury duty is not a fun thing to do, but it is an important thing to do and a vital thing to do. You have a 1-year disqualification from serving as jurors in state circuit court. You've got a 3-year exemption. I hope you don't exercise your exemption because we do need good jurors. And I want to thank you for your service. You're free to go at this time if you want to go. If you want to stay until the conclusion of the proceedings, you can do that as well. It's remain in the jury box. So it's up to you. As to those of you who wish to go ahead and leave now, you can leave now. Thank you very much. All right. Anything before we impose sentence?
No, Your Honor.
Well, first, I guess at this point in time, I know the rules of criminal procedure do allow a time period for post-trial motions. Is there any post-trial motions at this time?
No, we move for a judgment NOV by you based on the adequacy of the evidence presented, so that you impose the verdict as 13th juror. I haven't sat through the trial, heard the evidence. We make those two motions. And we would like a little time to flesh those out if possible.
All right. Well, I'm going to deny both motions for judgment NOV, and also the motion for the 13th juror. I think there's sufficient evidence presented to the jury that supports their verdict. As I said, the rules of criminal procedure do give you time periods to file post-trial motions, so I'll entertain any other post-trial motions you can do pursuant to those rules. I'll give you that time. All right, anything further at this time?
Your Honor, we are printing the sentencing sheet. We do have 2 victims who would like to address the court. Savannah Rice, who has been present the whole time, and then Zachary Rice, who is the victim's son from another relationship. With the court's permission via WebEx because he's not.
No, I'm not doing WebEx.
Okay.
All right, so once we get the sentencing sheet, I will give the victims who are present an opportunity to speak if they wish.
I believe Ms. Rice wants me to read her statement.
Well, I mean, we're not doing the sentencing sheet. I'll just hear from the
Okay. I need to fix my mic. I'm not. I am right here, right in the mic. Can you hear me? It's green. Green usually means that it's loud. If you can't hear me now, then it's StreamYard being wonky. Is it better now? Okay.
She just went back to records to get it, Your Honor.
These people know hundreds of people, thousands of people. I don't know. Hundreds of thousands of people around the world are waiting for them to decide.
Your Honor, I believe that Zachary Rice's email and statement that they must have already had prepared. So with the court's permission, I'll read that one as well. He's a statutory victim, Your Honor.
Yeah, but why is he here? He has the right to be here if he's not here.
Because he was forced to take custody of the children when their father was killed, and he has had to struggle to find jobs to now all of a sudden care for extra children.
All right, anything in mitigation from the defense?
You know, we asked you to give him credit for the time she was in jail, off of her sons, and credit for home detention. I don't have the exact figure, but I'd like to present that to you in our strong motion.
All right. Ms. Jackson, anything you want to say, or does anybody want to speak on your behalf?
Your Honor, she wishes not to.
All right. Any prior?
No, Your Honor.
All right, I'll hear from victims. It's done.
And Your Honor, did you need me to address the issue of home detention or not?
No, I'm not.
Your Honor, this is from Zachary Rice, who is the older son of Gregory Rice at the time. Once Gregory Rice was killed, Zachary Rice took custody of the 4 half-siblings. And he did this fairly quickly since we did not have WebEx available to him. He says 5 lives completely shattered, showed no remorse, waited 5 years for this, just celebrated Father's Day without him again. I would like the maximum in sentencing, took my father's life, and I want her to pay eye for an eye and lose hers. And then, Your Honor, if I can have Ms. Savannah Rice come up. Your Honor, she's understandably emotional. She says, Your Honor, I believe that my opinion for how long she should be sentenced does not reflect what has already been done. This crime has torn apart my family, others' families, and friends beyond any measure. My siblings and I have all suffered greatly, not only from the loss of my father, but the loss of a mother too, the loss of our lives. We have been waiting so many years for just a bit of closure, and this is it. We will never have the chance to freely live our lives without the thoughts of what has been done following behind us. It has become a challenge to rebuild and grow from everything that happened. There are still days where I just cry and wish I could go back in time to maybe prevent what happened. I can't do that though, and I will forever have the thought that I can't change anything alongside me. This trial and getting up on the stand has been one of the most heartbreaking and painful things I've ever had to do. It has also been one of the most relieving and rewarding things. I finally got to say what has been sitting in my brain the last 4.5 years. It was a relief finally being able to tell the truth and to go towards a cause. I believe that 50 years to life would be a sufficient amount of time. I thank you for your time, for listening to what I had to say. Thank you. Does Your Honor wish to address sentencing?
Well, if there's anything you want to put on the record.
Your Honor, the state is asking for the maximum term of life imprisonment. We believe that there is clear evidence that this defendant not only plotted and planned this murder, but also tried to frame the victim for things that she was doing. As Savannah said, and as I said in explaining why Zach couldn't be here. This really did destroy a number of lives. Zach was forced to take in 4 children, his half-siblings, as a result of them being EBC. After Meagan Jackson was arrested, we believe that there's nothing short of life in prison that would address this crime.
All right, Ms. Jackson, you have been found guilty of murder by a jury of your peers. The sentence of the court, I read it to say, the sentence of the court is that you be committed to the Department of Corrections for the remainder of your life. You'll get credit for any time, sir. All right, thank you. Thank you. All right, anything further from the state?
Nothing from the state, Your Honor.
All right, court is adjourned. Thank you very much.
Thank you, Your Honor.
Okay, we got another one done. Yay! Yay! Woohoo! That was fun. That's how you do it, Wiggles. That's how you do it. Boom, bang, in, out. That's it. Get in there, get out, get it done. I kind of don't want to start anything else right now. I want them to come back with a verdict today. And then I want to have 4 days off. That's what I want. I'm so tired. I want a little mini vacay. But I can't go anywhere because Travis has to work. Well, they don't even get off for the holiday tomorrow. And then he has to work this weekend. Saturday. He'll be off Sunday. So, I don't know. The questions that they asked yesterday, Flash, were pretty good for... It sounds like they only want to charge her with OUI. Unless it's only like a couple of people that are hung up on that, and the rest of them maybe don't want to charge her with that, or do, and then a couple don't. I don't know. It could be just a couple of holdouts, unless they, I don't know. Yeah, it's almost 2. They go to 4. Maybe they just wanted to finish lunch. Maybe they'll come. Maybe they wanted to finish lunch and they'll come back any minute with a verdict. And they can go home. I can go take a nap before I have to go grocery shopping tonight. We have a new Publix.
Welcome back to Court TV Live, along with Julia Janae. I'm Ted Rollins. The clock has now surpassed 20 hours of time that this jury deliberating the fate of Karen Reed has worked to come to a unanimous verdict on all 3 charges that she is facing. And to this point, they are still working. The lunch break has come and gone. This is usually that time when a jury that's close pulls the trigger, especially when you have tomorrow being a holiday. Tomorrow there is no court because of the observation of Juneteenth, the 19th, and that is courtrooms across the country. There is a question about Friday, though, because jurors originally were told you'll get Thursday and Friday off. At that point, Judge Cannoni didn't realize they'd be in deliberations.
That we'd still 27 hours last time.
We'll be here the way we are now, so there's a possibility, but they don't know. I feel like there's a lot that this jury does not know. They're in that room, they're in that situation where we don't want to bother them. We don't want to influence them at all. And for that matter, they may be in that room not knowing about Friday, whether or not they can take it off or should take it off. You see the crowds outside, our camera pointed outside of the courthouse, the crowds milling around, all waiting to see if an SUV pulls up carrying Karen Read, because that will signal that something is happening inside the courtroom and that they have received a notification.
And the big question is, what is this jury hung up on? What are they talking about? What are the issues, the main issues? What we do have is a juror from the first trial, a juror that came forward. There were several that came forward and spoke out, including one juror named Ronnie that spoke with Vinnie Politan. And Vinnie went through everything with him in terms of the different parts of the trial that maybe hit or didn't hit with that jury. Here is Ronnie talking to Vinnie about the cuts on John O'Keefe's arm and the taillight.
What did you think of the cuts on the arm of John O'Keefe? Did you believe it could have come from a dog?
Again, it wasn't conclusive. To me, it wasn't conclusive whether it was an animal or just abrasions due to glass or scraping against metal. But there was no conclusive evidence on where it actually originated from and where those scrapes or abrasions, how did they get there per se.
Let's talk about the tail light of the SUV. It was broken. It's clear it was broken. I'll start with your perspective. How do you believe the tail light was broken? What caused that?
Some sort of impact, clearly, that caused the breakage of the taillight. I think in terms of testimony, we would have preferred that the Dighton police officer who testified clearly indicated a little bit more information on whether the broken taillight was consistent to when he first saw it at the location at the Reed's residence versus, and then it was towed. And then also, it would have been nice to have some sort of testimony from the tow truck driver who transported it to the Canton Police Department, because in that sense, we would be able, whenever you move a vehicle, usually you take pictures or note any damage. So I would imagine that that tow truck driver probably would have had some sort of information, unless he did not do and actually write down any kind of date on the car prior to moving it to the Canton Police Department.
What's even more telling about Ronnie's interview there is he's a paramedic. He was someone inside of that deliberation room who had a bit of knowledge about medical emergencies. Let's bring in criminal defense attorney Robert Corbett. Is that illuminating for you, Robert? We love to hear from jurors after they are done deliberating, and it could very well be out of what's happening inside of that deliberation room this time around.
I would say it is very illuminating whenever you get a chance to speak with a juror, because some jurisdictions do not allow it. I always encourage people to take that, because you get the ability to insight in terms of some of the things they were thinking about or things they may have been hung up on. And the issues that that juror brought up, I am sure, are the same concerns that this jury is wrestling with, in terms of, if you cannot say definitively how those injuries were caused, that's reasonable doubt. If you can't say in terms of what cause, obviously it's caused by some type of impact, but you can't. And each juror can have their own reasonable doubt. They don't have to have a consensus. It can be a multiple of things. And one juror can have one reasonable doubt about this, and another juror can have reasonable doubt about something completely different.
One of the non-deliberating jurors from the first Karen Reed case ended up being part of the defense team this time around. Rob, how much do you think they leaned in as a sounding board with that individual as they prepared for trial?
I'm sure they used that person as a dedicated focus group in terms of if they didn't have a focus group for mock trials, but they would run by certain themes with that juror in terms of also ask that juror what was something during the deliberations that really stuck out to you, or what was some of the discussions in the previous jury in terms that really stuck with that jury and things that caused them to vote not guilty. And those things that were shared with the defense team, they were probably, I would say, just really doubled down on that and really honed in on those particular ideas so that they could probably try to get at least the same outcome by getting a hung jury, if not a better outcome by getting a straight acquittal.
Yeah, though she was not a deliberating juror, she was an alternate, but they certainly can talk about what her thoughts were as she saw all of that unfold last year. Rob Corbett, thank you so much for your analysis. We do have to say goodbye to you, but we've got a lot ahead because at any moment, we keep saying it, but it's because it's true. Until 4 o'clock and these jurors go home, they could return a verdict. They could have a question, and Karen Reed could return to this courthouse. Don't go anywhere. Vinny and Matt at the top of the next hour.
The juror that was an alternate last time is on the defense team now. But she hasn't been in the courtroom a lot. I think she's probably doing behind the scenes stuff. Can't believe we did a whole trial in how many days? When did we start that trial? Today's when we started that trial on Monday? Days? Well, obviously you can hear me some because you know I'm talking. I guess I'm just going to have to jam the microphone right into my mouth. I can't get my camera to turn back on.
that trial. We did that trial in 3 days. It was a 5-day trial. We started watching it Monday.
So, what's your message?
To find the truth.
Gotcha.
Find the truth. Get justice for John O'Keefe. Get justice for Karen Reed. This isn't justice, it's corruption.
The antics are at an all-time high. They're on the ground in Dedham, Massachusetts. Welcome back to Court TV Live. I'm Julia Janae. We are all standing by on a verdict watch, wondering if this jury is getting close to a verdict. Those crowds have been gathering at the Dedham courthouse for the past several days, all waiting to hear whether Karen Reed is going to be found guilty, not guilty, or is this jury hung in the question of how Boston police officer John O'Keefe died. Oh, wait, let's begin. Court TV crime and justice correspondent Matt Johnson, who is there on the ground outside of the courthouse. You've been there so many days, Matt, I can't even count, but here we are, day 4 of deliberations, the second time around. Tell me about what is happening around you. Seems like we're seeing more security, or maybe differently clothed security.
More security arriving.
All right, we have a bit of a problem with Matt's feed, so we're going to wait just a second until we see it clear up. I know there are a lot of cameras, a lot of TVU packs. That sometimes interferes with the signal. Matt, can you hear me?
Yeah, I can hear you. Can you? There is a lot of cell service going on out here, a lot of live view packs, which is how we transmit television nowadays, no longer the truck, and then also cell phones. Everybody's on them and waiting, watching that fan inside this building here, waiting for any sort of movement in the courtroom. We're going to show you, this is the growing crowd across the street. This is where we've been doing our live shots. You see the sea of pink. These are the supporters of Karen Reed waiting for any sort of a movement as the defense team is expected back here by day's end, whether or not there's a question or verdict or just to check on the jury. So where I'm standing, you can see the number of media from all across the country growing in numbers, especially as we continue this verdict watch, day 4 now. You can see the guards here up at the courthouse steps. These are security officers within the court. They've added additional security for this trial. Let's show you over here. Now they have this mic stand in place, which is something that we saw last year, because the media here now anticipating today could be the day, could come down to this, we could get a verdict, and then right after that, immediately there would be some sort of statements made by the prosecutor, Hank Brennan, perhaps, or by the Commonwealth just in general, Mike Morrissey, which we had heard from. And we're showing you video right now of last year when this took place at that mistrial on July 1st, 2024, where we had Alan Jackson addressing the crowd, and he was saying something to the nature of, we don't quit, we don't give up. And right after that, those charges were refiled, which brings us here today. Let me show you more cameras. It is a sea of cameras out here. A lot of friends in the media as we are waiting this out for this verdict watch. We're going to make our way down over here, and you can see there is more supporters over here. And there's also a lot of Dedham officers. They're always on standby just in case the defense team were to arrive. They usually go to this roped off area, this street that's been blocked off to the general public, and that's where they then enter the courtroom. We are waiting on pins and needles out here along with this crowd. We'll bring you any developments if we hear anything from inside the courtroom.
Matt Johnson, crime and justice correspondent, thank you for that update. Let's turn our attention now to Court TV lead anchor Vinnie Politan, who is also there in Dedham, Massachusetts, on the other side of the courthouse. Vinnie, what is it like where you are?
Yeah, I'm directly across the street from Matt. I can see him right out of my left eye. I can see Matt on the other side of the street. So behind me here, this is another area where people have been throughout the trial, but especially at this point during the verdict watch, waiting, anticipating what's going to happen. And as that clock ticks, I mean, think about it. Time is running out. Time is running out. for today, because we know here things end relatively early compared to some of the other jurisdictions where we cover cases. When we're in Florida, Julie Janae, I remember talking to you like 11 o'clock at night covering a verdict. So that's not the situation here. 4 o'clock is like the time where if we don't by 4, this jury knows that they won't be here tomorrow. I don't know if they know they'll be here on Friday, and they'll have to continue this. So right now is what I'm calling prime time. Prime time for a verdict is just about now. So the area I'm looking at is across the street where Matt was, right? So from where we are here, everyone gets a great view of where the defense team will pull up. It's from the back where John O'Keefe's family, when they're being mobilized. I think when they get in.
And you have to remember last time they had already been in, what, twice to say they were hung? Before they were hung for the last time, they got the Allen charge. Or what do they call it there? Tui Rodriguez or whatever. They got the Allen charge and then went back. So over however many days, 5 days or whatever, the 27 hours, they'd already been in there twice and said they were hung before the final time. So they've not been hung yet. So if they come back and say they're hung, it's not over. They'll be sent back for a Tui Rodriguez charge, whatever it's called. So it's not like they're going to show up and say we're hung and that's it. She'll make them go back.
Into formation, then something is about to happen. That's not happening at this second. But it's going to take time, right? It's got to get to the bailiff. It's got to get to the judge. The judge has to contact the lawyers. Then they've got to figure out what they're going to do with it all. In the meantime, the bailiff will have to word out the rest of security here. So what we're looking for is security formations that look a little different. We're also looking, and usually that security is in the area where the SUVs pull up. And we're also obviously keeping our eyes open for them as well. In the meantime, everybody here, I don't know. I don't know how they will react. I don't know what it'll be like if there is no verdict today. Let me ask a couple people. What happens if there's no verdict today? You coming back?
Of course.
Every day?
We ain't got no quit.
That's simple enough. Coming back. This coming here every day. No verdict today. Are you coming back?
The verdict's coming back today.
I understand that, but like, let's
am I coming
theoretically. You come
1,000%.
Okay.
Every day feels
Every day.
All right. What's your greatest fear at this moment?
The jury being a little bit confused on the slip.
Okay.
If it carries beyond today, the prolonged anxiety and stress, it weighs a lot on all of us.
I know you're here.
I am, unfortunately. It's the delays like this of the justice system that made me question that profession's.
Am I frozen again? Dang it.
Were conducted with the amount of ignorance of evidence so present, so obvious, the public trust and that of all of these people trust is going to be gone. And I should say that to all of those who support a guilty verdict here. We all should stand for something, moral certainty when we convict people. and honesty and transparency from our government, from our prosecutors, and from our judiciary. So if it comes across guilty, I will make it my mission in life to keep standing up and keep showing up to try to do something about it.
Thanks so much for your work. Obviously, she's a lawyer, well-spoken, but everyone here is doing some form of
Why? Why?
I want to let our viewers know, and you as well, that we are hearing that there's movement inside of the courtroom as well. We can't put our cameras down because we are not on the record, but apparently there is some movement.
They pull up. People are starting to file in there to fill that area up. The folks on this side of the street are now getting closer to the edge of the curb. Everyone anticipating that the defense team is about to arrive at some point in the very, very, very near future. And it's about them, right? This is one tap.
Okay, can you hear me now? Can you hear me now? Okay. They're from right now. I am so freaking nervous right now. I feel like I'm about to cry. I haven't felt this way since Johnny Depp trial, which is why I wore my Johnny Depp shirt today. It's all the funny things he had in the trial. You stop. You're not making it any better. Turtle Boy said if they find her guilty of OUI, this will be the most expensive misdemeanor trial in history. Why do we have to have a commercial break now? Go away. Go lay down. Go take a nap. Go. Or I can hold you again. You don't like it when I hold you. I don't know why you don't like it. Because you have to be pressed to my side all the time when we're in bed. It's the same thing. It's the same thing. When you lay on me in bed, it's the same thing as when I'm holding you in a chair. It is.
Why Karen Reed? Nobody knew her before this. You didn't know her before this, right?
Never, but...
Why her?
It could be us. It could be me. Could be you.
Why this case?
Injustice. Sandra Birchmore has a lot to do with this. Same cast of characters. And the police will not police themselves, and that's why I'm here.
Okay.
Justice for John O'Keefe.
Welcome back to Court TV Live. We are continuing to follow the verdict watch in Dedham, Massachusetts, Karen Reed's murder retrial, and we're starting to see some activity in and out of the courthouse. Let's go immediately to our lead anchor, Vinny Politan, who is on the ground. And Vinny, you said that family of Karen Reed's has arrived back at the courthouse.
Yeah. Take a look. The silent "I love you" signs are going up right now. Just across the street from where the SUV is pulling up right now, it looks like. We saw Karen Reed's father, but this is the rest of the team and Karen Reed arriving. It's after lunch. It's Wednesday. We've been talking about this all week. In a normal trial, this is about the time that you would expect a verdict. So whatever the notification is, whatever the reason is for them arriving at this moment, Complete silence as Karen Reed walks in. Let's listen. Never experienced anything quite like this, where you have hundreds of people supporting someone, waiting for them. They arrive, and there's a deafening silence in the streets of Dedham. That's exactly what we're experiencing right now as Alan Jackson, Karen Reed make their way into the courthouse, soon into the courtroom up on that second floor. And we'll soon find out what is about to happen. On the top of everyone's mind at the moment, is this the big decision? Is this the time when a jury will finally speak and finally answer the question, did Karen Reed murder John O'Keefe? So the quiet has actually continued now outside. I think people are feeling a sense of the moment itself. They've been here for
I'm
day after
streaming
day
it
after
from
day.
Court
They've been following the
TV,
case
Carla.
for years. And it could be in just a few short moments that they find out the result here, Julia.
Listening to that silence behind you and the way they're continuing to be quiet reminds me of the instruction that you said that they were receiving from Karen Reed, which is to be calm if there is a verdict. Let's bring in Court TV anchor Ted Rowlands, who is here in studio. And Ted, what are you thinking now that we are seeing activity inside and out at 2:17 Eastern?
This case is so unique in that we don't get any information, right? We're literally just trying to interpret. I think there's a verdict. Personally, just by the body language, I assume the parties know if it's a question or a verdict. You know, Karen going up and kissing her father, this seems like this might be it.
Let's see if we have Matt Johnson. I saw him asking Karen Reed a question, and her lips move, but I don't think we had the audio. So let's go to him and see if he can tell us what she did say, because Matt, she always seems to answer your questions.
Yeah, well, we've covered this trial since the very beginning. And I asked Karen Reed, who was walking notably with her father, if she was ready for a verdict. And she said, always.
What? Why? What? Go lay down. Oh, this is killing me. Can we see inside the courtroom at least? Something? I don't know. I'm nervous too. When we were waiting for the verdict in the Johnny Depp Amber Heard case, I was on the phone with my friend and I said, I have never been so nervous for something that doesn't affect me at all. I was almost sick. I was so nervous. Why am I so nervous? This affects me in no way whatsoever, and I've never been so nervous in my life. I'm not quite as nervous as I was for that, but I'm really nervous. Maybe diamond painting will calm me down. Not really, but it gives me something to do. This one's Snow White.
You are unmuted.
Hopefully that's the last time we have to hear that.
I appreciate you all getting.
Jury had not indicating that they had a verdict.
Shortly thereafter, they knocked again and said they didn't have a verdict. So I asked the court officer to tell them to put that verdict slip in an envelope and seal it, and to give it to us. Paul, do you have it? I haven't seen this. It's been sealed. I'm now going to seal it in the legal sense. So this is sealed. No one will have access to it. It will be preserved and made part of this record. I'm going to ask it marked for identification with the word jury, Chrissy, just to keep it separate and apart from everything else. So it's marked for ID with the word jury. All right. So we do not have a verdict because, as we all know, there is no verdict until it is announced and recorded in open court. So we are still awaiting a verdict. Because it took a while to pull this together, I would ask that everybody remain in the building until the end of the day. So we'll see everybody later.
Thank you.
Oh. What the heck? Come on, you guys. Yeah, I think we'd all love to know what that sealed verdict says. Why? Why would you do that? Why would you do that? Speaking of that, okay, this is the sign language symbol for love, right? Right? Everybody knows that. Okay. Rock and Roller Coaster at Hollywood Studios, Disney Hollywood Studios in Orlando. When you go in, the little pre-show thing, it's a film, but it's set up behind what looks like a recording studio. Come on, StreamYard. So it's set up behind what looks like a recording studio, and you see Aerosmith. And their manager comes in and says, hey, come on, let's go. You're going to be late for the concert. And so they say, but all these people need Eskimo for them to go too. And then, so that's the premise of the roller coaster, is that you're going, you have VIP passes, you're going. So that's the premise of the roller coaster, is that you're late for an air. Oh, is it? I didn't know that. Is that you're going to an Aerosmith concert. I love this roller coaster so much. And for the past couple years, they have said they were going to retheme it, because Disney is moving away from rides that they have to like lease the copyright for, and they're going to change it. Eventually all the rides, they've already rethemed. They had a ride called the Great Movie Ride. It's okay if we just chit chat, right? I'd rather do that than listen to people speculate. Is that okay? If not, I can turn it back on, and actually, instead of pausing it, I think I'm just gonna mute it. That way we're
Judge
up
Cannone
to
is in.
date. We can
On
watch
this
the
case in
clock.
terms of how to deal with jurors, how to communicate.
And then we can still see the clock and everything, and then this shit. Okay. So they rethemed it. Was the coolest ride. I love it. It's you through. If you can hear me, if you can still hear me good, because if you can't hear me, then we don't want to hear me. She was found guilty and sentenced to life in prison. I TV declare less copyright star. So there was a ride called the Great Movie Ride, and it was Disney Studios used to be Disney MGM Studio. So like they had this deal with MGM, and it was a slow movie ride, and it moved you through movie scenes. It had Singing in the Rain, aliens. That was really cool because aliens would pop out of the wall and pop out the rain. It had Indiana Jones. It had I just drew blanks. One of my favorite movies, Wizard of Oz. It had Wizard of Oz. It had Casablanca. It had all these old. It had a John Wayne movie. It had all these old movies. They were all animatronics. And it was a really, really cool ride. And at the very end, because the cars were one ahead of the other, at the very end of the ride, the cars pulled up side by side, and there was this giant movie screen. It reminded me of being in a drive movie, and it showed all these different scenes from all these great movies over the years. And they have just it's been probably a couple years now. They rethemed it to a Mickey and Minnie ride. And in California, they have a drop tower. It's called the Twilight Zone Tower of Terror. And it's, when I was a kid, well, not really a kid, but like a young adult, and because it wasn't there when I was a kid. I didn't understand, because that's like the infancy of AI, right? AI's everywhere now, but I couldn't figure out how they put Rod Serling in an episode that never existed, because it looks like that's really Rod Serling standing there introducing a Twilight Zone episode. But if you can tell, it's not his voice, though. It sounds a lot like him, but it's not his voice. But it looks just like he's, just like he did on the show, he's introducing an episode. So, I love drop towers. Travis doesn't like them either. He won't ride it with me. We're going for our anniversary. I'm going to try to get him on it. But that has been rethemed in California to Guardians of the Galaxy. Because they don't have the Tower of Terror license there anymore. So there's 2 left, and it's Aerosmith Rock and Roller Coaster and Tower of Terror that we have here. So they're going to retheme Rock and Roller Coaster to Muppets. It's going to be the Electric Mayhem. It's basically going to be the same premise that, well, let me keep going. That's, it's going to be the same premise, but it's going to be the Electric Mayhem, which was the Muppets band with Dr. T and Janice and them. So it's the same thing when they were conference. So it's going to be the same roller coaster. But at first, when they said that they were going to retheme it, was because Steven Tyler does this. This is sign language for I love you, right? This was the problem. Because apparently it is a symbol for tongues. And I figured out because I'm not going to say it on YouTube. But I had never heard that before. But it would have to be sideways to be a symbol. Not that I love you. He was telling his fans to love them. But of course, somebody has to turn around and make it be about sex and go complaining about it. Which that may have just been a rumor that somebody started spreading around, that that's why they were going to retheme it. Because it seems like a few years ago people were saying that he was going to get in trouble because back in the day, groupies, but isn't statute of limitations like that way in what, 70s now? I think the statute of limitations has gone way past that. Yeah, I think that's why Travis is very, very afraid of heights. And StreamYard's not going to put your thing up. But the thing with the, oh, there it goes. The thing with Tower of Terror is you're inside an elevator. So you're in an elevator shaft. You're not on the outside of a tall stick thing like you are in most towers. So there's really, you don't see the heights. When you get to the very top, there's like a slit you can see out of. But you're not completely outside the whole time. So you're in an elevator shaft. Oh, was it? Now that makes more sense. If it's a gang symbol, that would make more sense. But no, I've always thought, and when I saw it on the thing, now if you can actually find it on YouTube, come on, StreamYard, put the comment up. There it goes. You can look it up on YouTube. It'll show the whole like pre-show and everything. And it's really crappy if you watch it on YouTube, because it doesn't, you don't get the effect on video. But if you're there and watching it, it looks like you are standing in the same room with Aerosmith. It's an amazing effect, and I am going to miss it. I'm a huge Aerosmith fan. Our song, mine and Travis's song, is Don't Want to Miss a Thing. And thumb out is I love you. The thumb in is something else. I thought that in the sex thing, the thumb was to do something. Oh, the thumb in is the gang symbol. Oh, okay. Yeah, I've been on stream. It's not going to let me put comments up. Well, they are, but it's slow. Where's King's Dominion? Zombieland. No, in Zombieland, when they're at the amusement park, the drop tower, where they're at the very top of the tower trying to get, get away from the zombies. I've been on that drop tower. That was filmed at place. I talked about it the other day. Remember, I told you I didn't like it that much, and then I went, "Oh, I should have said the name of the park." Wild Adventures in Valdosta, Georgia. And there's another movie that was filmed at Universal. I haven't been on that roller coaster yet, though. Dang it. It's a remake of an old Vincent Price movie. Is it 13 Ghosts? No, it's not 13 Ghosts. Is it House on Haunted Hill? Is it House on Haunted Hill? Not the Haunting of Hill House. That's different. House on Haunted Hill. Yeah. House on Haunted Hill. That's it. The original movie was with Vincent Price, but the remake is with Meagan Jackson, who played Jean Grey in the X-Men movies. And the Hulk roller coaster at Islands of Adventure, I guess they had finished it, but the park wasn't open yet, and they filmed part of it. That roller coaster was in that movie. And I haven't been on it yet. I'm afraid to. But I'm going to. After all the water slides that I've ridden lately, I've decided I'm not afraid of roller coasters anymore. I'm ready to ride them. If I can ride down a steep slope, not buckled into anything, just on a little float, then I can be strapped into a seat and ride a roller coaster. I love Haunted Mansion. I love Haunted Mansion. Ride in both movies. The first movie with Eddie Murphy is in the remake, though. I don't know. I didn't see Game of. All I've done was that movie, X-Men, and an episode of Star Trek: The Next Generation. I think that's all I've seen her in. Every time I have done to my back, I always ask if I can ride roller coasters. My cousin right now is going through this thing. 21 hours. Clock is stopped. My cousin, before she had her last back surgery, she's ready to ride Velocicoaster because she loves it. And I've been saying it's been there 4 years now, and I keep saying, nope, not going to ride it, not going to ride it. My girls love it. My cousin loves it. They've been trying to get me on it, and I'm like, nope, not going to ride it, not going to ride it. How excited I am. She's like, oh, you're going to love it. You're going to have so much fun. And now, after her surgery now, she's in pain, and she's crying, and she yelled at me the other day for talking about roller coasters. I said, the last thing you said to me before your surgery was, you're going to love Velocicoaster. We're going to have so much fun. She's like, I might not be able to ride them anymore. I said, would you ask your doctor before you get all depressed about it? You're going to be able to ride them again. I think I would like it, but I don't like things with sex in it. Sex can be implied. It doesn't have to be in your face. It can be implied. I can only do it with my right hand. Something I can't do it with my left. I can't get those two to stay together. William Shatner can't do it at all. And the one he never had to do it, but he had to do it in one. He did it. They did it with fishing wire, and pulled his fingers apart with fishing wire from off stage. But I don't know. I can't do it. Can't figure it. Come on. I'm scared. I'm so scared for her. Yes, the first movie. I went to see the second one with my friend, and I was like, the Eddie Murphy one was better. And she goes, there's one with Eddie Murphy? I was like, yes. You need to go watch Eddie Murphy. I didn't know it was Eddie Murphy. Yes, it's fine. And it came out. 3 movies came out to match the 3 Disney rides that didn't really have movies. And it's the Caribbean, Jamboree, and the other 2, well, Country Bear Jamboree was stupid. Or Country Bears, whatever the movie was called, was stupid. But I think the reason why Haunted Mansion didn't do better was because I don't remember which movie it was. They have, Universal has Halloween Horror Nights every year, and they have different haunted houses themed to different horror movies. And I went years and years and years ago, before they started theming them to horror movies, when they were just haunted houses. And I went through one, and that was it. I'm like, nope, I'm done. I'm never coming back here again. And I haven't. Not for Halloween Horror Nights. Been during the day. My Michael Myers shirt that I wear, my Halloween shirt, my Michael Myers shirt, I bought it, and it says Halloween Horror Nights on the sleeve. And I usually don't buy souvenirs if I don't go there, because I just think that's stupid. You need to, if you're going to buy a souvenir, you need to have experienced what you bought the souvenir for. That's my thing. But it was so pretty, and it has everything from the movie. It has Michael, it has young Michael as a clown, it has the house, it has the knife, it has the pumpkin, it has everything from the movie. It says Halloween. It just looks like it's a shirt about the movie. It doesn't look like it's anything specific to Halloween Horror Nights. I was like, I have to get the shirt. I don't care if it says Halloween Horror Nights on it. And I did get it at Universal, so I'm like, I don't care. And I wear it all year long. I don't care if it's Halloween or not. I'm wearing it all year long. I don't think any of my ceiling fans are white, and the one in the room I'm sitting in is white. Only mine has gold filigree on it. All the other ones are brown though. We took that one from our trailer when we moved here. All the ones my dad. Near, far, wherever you are. Carla, did you see my Snow White? Did I make it? I don't know if I have a Snow White pin. I've got oodles and oodles and oodles of pins. I collect pins. You can't. Stringer, this is not funny. This is not the time to do this. Not the time to do this. And now I'm gone. But these are my Disney pins from the park. It out for different. I think these are Disney pins came from other places. And then they empties because I have some on my lanyard.
That's what's taking place right here. The general tone, if I had to describe everyone.
And this one is full of pins that I got from Disney Movie Club. So it's not full. I quit when Disney Plus came out. I quit getting the movies from Disney Movie Club, but you get all kinds of cool stuff for free with Disney Movie Club, or very cheap. See, like, I think the pins are like $1.99. And then also with they call them lithographs, with the whatever movie you got, that's Captain America Civil War, and Guardians of the Galaxy. Some of them I have framed on my wall. There's Mary Poppins Returns. There's Incredibles 2. The live action Cruella. So if you get if it's like their featured movie, Finding Dory. If you get their featured movie, you get the little picture that goes with it. Spike, you've been in the garbage can again. That boy out of the garbage. Travis put one of the Disney Resort wax melts in my wax warmer in the bedroom. It smells like Disney in my bedroom. And this is all. Why does that feel sticky? It's not supposed to be sticky. I was gonna start a new stream with a new thumbnail, and then I didn't. I'll cut it off and fix it later. What is taking so long? These are the only Universal pins I have yet. They're all Harry Potter. So I've got McGonagall and Dobby is free and Hufflepuff and the Deathly Hallows. So my Universal pin collection is very, very new. Even though we've been going there for a while, I just haven't quite got a good collection. And SeaWorld now has pins and trading too. But I read somewhere recently, I don't know why Disney's doing this. When I went a couple years ago, my cousin and I went just to go Christmas shopping. We stayed at one of the resorts, and we went to Disney Springs for lunch and Christmas shopping. And they now have these pin trading things set up. There's a board of pins, and there's a cast member there, and you can trade pins. But the ones you trade for aren't nice. They're not as nice as the ones that you buy at the pin kiosk for like $13-14. And now people are trading pins, but what they're doing is they're buying knockoffs online and then send pieces and trading pins. So people are getting ripped off because they think they think they're trading for the real thing, and they're not. So I read the other day that Disney is closing down one of their pin trading stations because it's like a flea market out there. People are just sitting out there with these knockoff pins that they've bought online, and they're trading them for the nice, good, expensive ones. Why do this? Why have people just around doing pin trading? You really park if you do crap like that. Let people sit out there and take advantage of people that are paying good money for your pins. Stupid. If that wasn't a clip, that could be our verdict thing. But Disney would copyright us on that for sure. Futterwhacking.
Will the deliberating jurors remain standing?
12 deliberating jurors, 6 alternates. Mr. President.
Yes.
May I quiet?
Yeah. Yes.
Mr. Foreman, members of the jury, have you agreed upon a verdict? Yeah. Thank you. May I see the papers? Mr. Foreman, on docket number 2282 CR 117001, murder in the second second degree. What say you? Is the defendant at the bar guilty or not? Say you? You agree? Yes. Do all of you agree? Guilty or guilty? Not guilty.
Of.
Liquor by operating a motor vehicle with a blood alcohol level of 0.08 or greater, correct? Yes. So 03, what say is the defendant at the bar leaving the scene at test, the defendant not guilty or guilty? Say the defendant on 001 not guilty, on 002 is guilty of operating under the influence of liquor, and 003 not guilty. Thank you.
All right, jurors, everybody please be seated. Jurors, we thank you for your service. We're going to send you back. Your service is complete. I'd like to come back and talk to you for a little bit afterwards. So thank you very much.
All rise. Jurors, follow me. Can you please exit the courtroom immediately?
Karen Reed.
Not
yet.
Tony,
Hold on,
not yet.
hold on,
Not
everyone.
yet.
Karen Reed. Ms. Reed, can I have your attention? As required by statute, I must inform you that the records regarding the charges that you have been found not guilty will be sealed by the Commissioner of Probation by the court unless you notify the Commissioner of Probation in writing within 10 days that you do not want these records sealed. To request that these records not be sealed, you may use the Request Not to Seal form, which is posted on the trial court's website on mass.gov. I cannot accept the form here in court. You must submit it to the Commissioner of Probation at the address provided on the form. Please be aware that if the records regarding the charges which you have been found not guilty are sealed, you will be unable to access the sealed record of the not guilty dispositions or any other records regarding those charges. If you want copies of any documents regarding those charges before the records are sealed, you should request copies from the court within 10 days. Do you understand? Thank you.
All right, so we need a date for sentencing. Can we do it next week?
We would be prepared to go forward today.
Okay. Okay. All right, so Mr. Yannetti, you're ready to go forward today as well?
Yes, please.
Okay, Mr. Brennan, what's the Commonwealth's recommendation?
Your Honor, the Commonwealth moves for sentencing. We recommend probation, 1 year, 24D program.
So the standard that everybody else gets on their first time OUI?
Certainly.
Okay.
We ask that she be treated no differently, no better.
So I'm happy to do it.
Thank you.
All right, thank you all.
1 year probation on docket number 002, the lesser included offense of operating under the influence. 1 year probation. Thank you. The 24D program is.
Please exit
Thank
the
you.
courtroom immediately. All rise.
Goodbye.
Be safe. Show us the crowd outside.
There's Nick Rocco and the rest of the supporters who were inside the courtroom for the verdict. Never experienced anything quite like this. And the emotion is real. And people aren't faking it. They're not forcing it. Massachusetts. I've been calling it the retrial of the century because it's the retrial of the century. And the retrial ended with not guilty verdicts across the board. See some more of the security and we wait for Karen Reed and the defense team to exit. I think everyone realizes what an explosion it will be in that of sound. Everyone's got their phones up now recording the moment after experiencing the moment together outside of the courthouse. The only lingering question for me right now, though, is John O'Keefe's family, if they're going to take them out the back of the courthouse, because there is an exit out the backside, and I think that would be the smart thing to do for that family. But for Alan Jackson, David Kennedy, and Karen Reed, this is going to be their moment. We've seen it through the years at Court TV several times. It's been a few years, though, since we've seen anything even close to this, because it's overwhelming support for the verdict that the jury handed down. I don't know if Matt Johnson can hear me. Matt, do you hear me?
Yeah, I can hear you. All the media is assembling right now on the courthouse steps. We're waiting for Karen Reed and her team to assemble down and leave the courthouse. A lot of police presence out here on the courthouse steps and on the sidewalk addressing the media. We're pushed out all the way to the edge of the street. And we are just anxiously waiting for all parties to exit the courthouse here. Now, I am wondering if some of the parties might choose to exit through the back. That's where the jury had been entering and exiting the courthouse until now, so we know that that's an open opportunity for them. But, yeah, it's just a waiting game right now from my vantage point. We're at the podium waiting for Karen Reed to address her supporters and address the media.
Matt and Spot, Nick Rocco has been on my show throughout all of this, one of the leaders in raising funds for this defense team. He's not a lawyer. He's never been involved in anything like this, but saw a cause, raised money, and helped this defense team. You can't put on a defense like this without the funding that is necessary for the experts, for the lawyers, for the expenses. You have a lawyer from California, you have a lawyer from New York. All that's got to be paid for somehow, some way, and that's another part of this story. The over $1 million that was raised for Karen Reed, much of it by the people you're seeing right in front of this courthouse. as we wait for the moment and coming down, found guilty of only a minor charge of operating under the influence, which is tantamount to a throwaway compared to what she was facing for manslaughter, leaving the scene, accident with death involved, and of course, murder. So this is a win across the board. It's a celebration in the streets of Denham. They've pulled down the street in front of the courthouse. My guess is they don't do that too often, but it was the right thing to do to give enough space for everyone here so gets trampled, no one gets harmed. And right now, I'm just anticipating that moment. I know we've got the rest of our anchors in the home base studio. So Michael Ayala, my friend, we've been through this for decades together. I know when they come out, you'll be cut off, but what are your thoughts?
Listen, I said from the beginning, Vinny, the only thing that I think beyond a reason what was proven by the prosecution in this case was the fact that she drove drunk at some point. And again, the jury seemed to make the distinction between the 12:45 and the 5 a.m. in the morning, because we know that breathalyzer test, and she wasn't tested, that blood alcohol level, wasn't taken until 9 a.m. that morning. So they made the distinction. Was she drunk at 12:05? Was she drunk at 5? Clearly, 5 o'clock. Was she at 12:45? We don't know. But I always felt at 5 o'clock driving that truck, she was drunk, because by the time she got to the hospital at 9, she had an alcohol level that was above the legal limit. And that's the one that they stuck on. It looks like they were there. They fought through this. Maybe there was back and forth as to maybe something a little higher when they were stuck on involuntary manslaughter. The first round, maybe there was discussion about that. But ultimately, I think they came down on the one charge that one can say was truly proven beyond a reasonable doubt.
And more celebration. They just sang the Star Spangled Banner here outside the courthouse. Something else that we've seen as we got closer here in the buffer zone, there were no Karen Reed signs, so they started passing out American flags. That's been another part of this. Part of the cause and the justice that people are seeking was, hey, this is the United States of America. We want justice. So for all these folks, they believe justice was served today. They believe justice was served. And again, the anticipation of the moment, no one's going to leave here until Karen Reed walks out of the courthouse, flanked by Alan Jack. It's unusual. It's unusual for a not guilty that this is where we are and what's going on. Let me talk to you. What are your thoughts right now?
You are all set, Ms. Reed. Free Karen Reed, I love you. Thank you. Thank you for everything, Karen.
All right, we'll come through here. Thoughts at this moment?
So excited. Couldn't have asked for a better outcome. Woo!
There you go. Woo, woo, woo. Speaks volumes. Young children with American flags.
How you feeling right now?
How you doing? What are your thoughts?
I'm excited. I'm so happy. I've been waiting for this we all have for a long time. Game over.
This is Massachusetts history. Massachusetts history. We got the justice that we deserve for the O'Keefe family as well. We send our love.
Thank you. The last time we had a verdict of this magnitude in this town, in this courthouse, was Sacco and Vanzetti. Much different scenario. Over here you can see Turtle Boy, who is very much responsible for beginning Free Karen movement, which took off.
There, you see everything. My spot.
All right, we're gonna move our spot. We're going up the steps. Excuse me, pardon me? Pardon me? I'm walking through another sea of pink, another sea of pink.
Vinny, you were right. You did it.
Yeah. All right. This is an interesting perspective. We can turn and look here. The crowd, and you'll see the reaction when the next big moment happens. The first big moment, obviously, the not guilty verdicts on everything but operating under the influence, which is a throwaway. Another way for Karen Reed and defense team. I know Ted and Julia also stand. I don't know if Judge Ashley is there as well. But why don't we go to Ted Rollins? Your response.
I have to tell you, when you talk about reasonable doubt, there was reasonable doubt in this case. Whether you believe Karen Reed hit John O'Keefe or not, the investigation, the way the authorities, specifically Trooper Proctor and others involved in the investigation, is the reason that she was found not guilty unanimously by this jury. I can't imagine being a juror on a case like this with the behavior of the investigators and returning a guilty verdict. It would be hard to live with. I truly believe there is a direct connection between the investigation and this verdict.
Yeah,
I bet
your thoughts.
happy too. I'm just amazed at this sea of people that has grown over the days. People just want to be Claire Reed, this person who was not a celebrity before. No one knew who she was, but something about her story sparked something in them that they felt so deeply convicted about her cause. And this was just one of those cases where they're saying that they want justice for John O'Keefe as well. But what is justice now? I'm thinking about his family. They have got to be heartbroken in this moment. After 2 trials, after sitting there day after day, the woman that they believed killed their son, uncle, their brother, is walking free. And I'm not saying that she should be walking this legal, because all of these believe someone else was responsible, but we know there's not going to be any other prosecution, no other charges in this case, but this is certainly a fantastic legal team theory, and they...
A day unlike any day we've experienced at Court TV. What are your thoughts right now?
Unlike anything that we've seen, this is definitely the recent count. The podium is set up. We're waiting to hear from this defendant. Over the past couple days, she has not been answering any questions. This defense team, along with the prosecutors, they've been under gag order after this very lengthy trial. That wasn't the case in the first time around. I mean, you have to think back to how each case, the Commonwealth and also this defense team, ended their case with those dynamic and powerful expert witnesses, from both sides. And the amount of money that was spent on this trial, on $1 million for experts, you had this defense team that raised just as much. And now you have a situation where there's been 2 trials and no conviction. I think that there is going to still continue to be a lot of questions in this community. Everyone that you talk to is still divided. A lot of people tell me that they cannot talk to their family members at holidays with this case. I think that remains the same. I think that what's different is this is a chapter closed for all these families. But there's another chapter on the horizon as well, because Karen Reed, this defendant, now acquitted of these charges, is another trial, which is going to be a civil suit. And I thought it found to invest time, and this defense team are happy that she's coming home.
Absolutely. Looks like let me get in. Okay. Let's take a quick break, folks. These faces, it's jubilation in the streets of Dedham. Our coverage of the Karen Reed guilty verdict continues.
Sandra Birchmore, because I always get this wrong. She's an organization for teenagers. Why is my computer rebooting itself? My laptop's rebooting itself. I didn't tell you to reboot. My tech is going crazy. organization for teenagers that wanted to be in law enforcement. What was that thing she was in, Judy? So the it wasn't in Canton. It was in another town, right? So they groomed her, and I think there was more than one of them. They essayed her. And can you hear me? It muted me again. Junior law enforcement group in high school. Thank you. I don't know why I can't get that in my head. So, they essayed her. And okay. I don't know why I cannot remember junior law enforcement. So they essayed her. She, I guess, as an adult, had a consensual relationship with one of them, and he got her pregnant, and then unalived her and made it look like she did it to herself because he was married and didn't want anyone to know that he had gotten her pregnant. And some of the same troopers involved in that was involved in this. And then there was another case of a guy named Brian Walsh that unalived his wife, and some troopers involved in the case. Oh, that case. I don't know if he did it. Some of the same players are in that case as well. So it's kind of like when they talk about one case and the corruption, they talk about all three of these cases. What is going on? Things are beeping at me. My my laptop rebooted itself. StreamYard keeps telling me to wait, and I'm not asking it to do it. My mic is gone again. Dang! I give up. I give up. I give up. I hate you, StreamYard. I hate you so much.
Second degree, what say you? Is the defendant at the bar guilty or not guilty?
Not guilty.
So say you, Mr. Foreman? So say you? No. Do you agree?
Yes.
Do all of you agree?
Yes.
Thank you. 002, what say is the defendant at the bar not guilty or guilty?
Not guilty.
Of?
Any lesser included charge? 0.08 or greater, correct?
Yes.
So say you, Mr. Foreman?
Guilty.
So say you all?
Yes.
003, what say is the defendant at the bar leaving the scene after accident resulting in death? The defendant Ms. Harkenberg is reporting upon the defendant on 001 is not guilty, on 002 is guilty of operating under the influence of liquor, and 003 not guilty. Thank you.
Well, we're continuing coverage of the verdict in the retrial of the century. Karen Reed not guilty of every charge that actually counts. Guilty of operating under the influence. Not guilty. Right now we're outside the courthouse. Street is blocked off. You see. Right now there's a chant of justice for John, which is justice for John O'Keefe. Because the folks outside this courthouse believe that justice for John O'Keefe is an investigation of the investigators, investigation of the people who are inside 34. That's a long time. Investigation's not happening. There will be no more. It's everything that they've been talking about year after year in the build-up to this moment. Matt is also outside the street. Matt himself, but can you hear me? That's the love here coming from the folks. I look at some of the faces, a lot of smiling faces. Why are you so happy?
Karen Reed is free. Woo!
Why is that important to you?
I love Karen Reed. We've been following this case for a long time. Freedom for Karen is justice for John. Yeah.
What happens next?
It just does. I know that's not something people like to talk about, but you know, the support. Now, he was, of course, a celebrity. It's Super Bowl. His case, you know, in trying to think, Vinny, about why these people are so behind Karen Reed, I can think that she just represents all of them. They all use with the police out there, corruption, the she represents all of the problems had over the years, and now it's come to this point, and they're just letting them show.
Absolutely. All right, we're going to sneak in a quick break. When we come back, our continuing coverage of the verdict in the retrial of the century. Karen Reed basically being set free today.
But I love you guys. I'm so glad that you guys are hanging with me through all the technical difficulties. I love you all. And I wish they'd come out and do their little press conference thingy. So I can go get a power nap before I have to go grocery shopping.
Welcome to downtown Dedham. Not guilty, Karen Reed, and she's about to exit the courthouse. This moment will speak for itself.
The Celtics won the NBA title last year. On the Friday last year, they had the parade. Now, a whole different ballgame.
I could not be standing here without these amazing supporters who have supported me and my team financially and, more importantly, emotionally for almost 4 years. And the second thing I want to say is no one has fought harder for justice for John O'Keefe than I have and my team. Thank you.
So you want to see it reopen? Karen, you want to see the case reopen? Give a message. Should the case be reopened? No, the case cannot be reopened. Alan, what case is over? No, I mean the case is searching for someone else. What did you say? About testing? I'm going to leave it. I'm going to leave it to Karen. Let her dad. Let her dad investigate that.
Mr. Reed, I want to acknowledge the strength of our daughter Karen, the support of the entire Reed extended family. I want to acknowledge the greatest team attorneys. Our first one that we found was David Yannetti. We added Al Jackson and Rice a little. Alessi, you know about. All right? There was a fantastic team, but we needed them all to defeat this. We thank everybody for this support from the heart. We love you all. All of the content providers.
Karen, what is life like going to be for you now? Karen. Karen. Karen, what is life going to be like for you now? How do you feel? You okay? You okay? You okay?
Unbelievable moment. Unbelievable moment. The swarm of pink now moving from the front of the courthouse down towards the SUVs as Karen Reed and her defense team settle into this moment. Settle into an unusual moment in our system of criminal justice. A not guilty verdict in a murder trial. It doesn't happen often, folks. It really doesn't. When you accuse prosecutors and law enforcement of a conspiracy, it is rare that a jury believes that is reasonable. It just happened in this case. It was about trying to prove a case beyond a reasonable doubt and a jury finding reasonable doubt in every criminal charge that mattered in this case. Operating under the influence is the only one that they found her guilty of. Matt Johnson on the street as well. Matt.
forefront.
Do you feel
We just got a comment from Reed. He's making it to his SUV as they're all making their way out of this situation after the verdict, and he's saying that he was thankful to all the supporters and thankful to the media for drawing attention to this case. This community for more than 3 years. As for Karen Reed, I was really trying to get a comment for her about what life will be like now that she is no longer a murder defendant. She had no comment. I asked her probably 4 or 5 times. She did not make any comment other than what she said at the podium, really thanking her supporters here, and also thanking all the media that have been out here and her defense team that have been working on this for the past 3 years. And then she's added Vice Robert Alessi, and also adding a former juror to her team. A lot of interns that were also researching and doing a lot of work behind the scenes from Harvard University. This defendant waving and making the love symbol in sign language as she drives past all of the media and drives out of after being. You can see out here all of these supporters. Many of them were in tears during this process. We're reading the verdict and cheering, and just these supporters that always believed.
Unbelievable scene. It's like, now what happens? What happens next? Right? The rush of adrenaline.
Live outside the courthouse.
Closing arguments tonight at 8/7 Central, only on Court TV.
Can you guys hear me? Can you hear me? Frozen? The crowd is gone now. Okay. Just me. No other noise. You can hear me now? Okay. Are we good? I just want to say bye. I am so tired. You guys, this has been one of the most draining things I've ever done. I don't know why this has drained me so bad. I cannot believe we did that whole trial in 3 days. I mean, well, it was only a 5-day trial, but we did a whole trial while we were on verdict watch for Karen Reed. And now I'm taking 4 days off. Do not bother me unless your name is Jill or Judy. Okay. I will see you guys Monday. No, I'm kidding. Go ahead and bother me if you need to. I will see you guys Monday. Unless I need to see you earlier than that. So make sure you have your notifications on. I'm probably going to do a short in a few minutes about the verdict. But other than that, I'm so tired. Yesterday, I told Travis I was tired. And he goes, "What's wrong? You just feel drained or what?" And that was all he had to say. And I started yelling, "I have to do this and this and this and cook for you. And Belle barks for cookies all the time. And blah, blah, blah." Oh my God. I need a break. He's like, "All right, you don't have to yell at me." I'm like, okay. I'm sorry. I'm just so tired. He doesn't understand. He's like, "You're just sitting there all day." I'm like, dude, my head is on a swivel. I've got 3, sometimes 4 screens to watch. I've got the dogs to handle. I got to cook for you. I got to sprint to the bathroom to pee because I'm worried about StreamYard crashing. I have to fix my I'm like, you just don't know. My brain is in constant motion for hours at a time. And when I go to visit him at work, what is he doing? He's sitting in the chair playing games on his phone. So he doesn't need to be thinking I'm sitting here doing nothing. And I have to go grocery shopping tonight. So I'm going to go take a nap. I'm so tired. I'm so happy though. I'm tired and happy right now. So I will see you guys Monday morning. Have a nice break. Enjoy the holiday. Have a nice weekend. I'm going to go sleep. Well, after grocery shopping tonight, I'm going to go sleep all weekend. I will talk to you guys on Monday. Unless I get bored. And then I might do something Friday. But I don't know. I can't even think right now. I'm so tired. Bye, guys. I love you. Have a nice holiday and weekend. Bye.